Good morning, sir.
Good morning.
Pronounce your last name for me.
My last name?
Huh?
Lorga.
How do you say it?
Lorga.
Lorgea?
Yeah,
Thank you.
Lorga.
Did I get it right? Lorgea?
Yes.
Mr. Lorgea, you are with us based on an allegation of grand theft, motor vehicle, possessing cocaine, and resisting an officer without violence. Took a look at your charging affidavit, and I do find probable cause for your arrest. I am going to set bonds in your case. Your bond in count 1 is going to be set in the amount of $1,000. Your bond is to count 2 is going to be raised up to $500, and count 3 is going to be $500. So total bond amount of $2,000. I will appoint the Office of the Public Defender to represent your interests. Thank you. Is it pronounced Goff?
Yes, Your Honor.
Thank you. Mr. Goff, you are here with us based on an allegation of trespassing in an occupied structure. Case number is 2022 MM234. Can't see the last number.
Judge, may we approach on this case?
Sure, come on up.
I'm coming, sorry.
All right, I've been made aware that, Mr. Goff, you wish to resolve your case this morning. I'm going to place you at the back of the docket, so we'll hold on to you and have a more detailed conversation with you here in about an hour. So,
Yes, Your Honor.
thank you.
Amen.
State of Florida versus Wrightsa Ritchie.
Yes, ma'am.
Good morning, ma'am.
Good morning, good Sunday morning. I know it's Sunday because I just came out 3rd and it's November 25th, 2022.
Imagine there's a lot more ways that you would like to spend your Sunday morning. Can you tell me your last name, please?
What's your last name?
Papa, Richie, R-I-C-H-E.
Do you pronounce it Ritchie or Richet?
Richie en français, Richie in English.
Ms. Ritchie, you are here with us. The allegation is resisting an officer without violence. I have taken a look at your charging affidavit. I do find probable cause for that arrest. I am going to set a bond in your case. I'm going to lower your bond down to the amount of $250,
Jesus.
and I will appoint the Office of the Public Defender to represent you.
Thank you. God bless you.
Yes, ma'am. God bless you as well.
Your Honor, what was that bond amount?
I know I'm
Thank you.
State of Florida versus Dorcelli Abdias. Good morning. Can you hear me okay? You don't wish to speak? That's fine. All right, I'm not sure, let's see. This gentleman was initially booked on a trespass on property after warning and resisting an officer without violence. I have a copy of the charging affidavit. It appears that our John Doe has been identified. Court finds probable cause for the arrest. I'm going to set bond the amount of $250 as to count 1 and raise the bond in count 2 to the amount of $500. I will appoint the Office of the Public Defender to represent Mr. Dorselli's interests. Thank you. State of Florida versus Shaquille Irby. Ms. Lampier, do you wish to reset or waive?
We'll waive, Your Honor.
Court is going to accept the waiver of Mr. Irby's appearance, appoint the Office of the Public Defender to represent his interests. He was charged with a allegation of possession of MDMA and violation of a domestic injunction. Bond in count 1 is going to be set in the amount of $1,000. Bond in count 2 is going to be set in the amount of $1,000. He unfortunately is out on bond on a felony offense. That is in 2022 CF 9713. Court has probable cause to believe he has committed a new law offense. Court is going to revoke his ROR, and bond will be set in the amount of none. Office of the Public Defender is also appointed on 2022 CF 9713 if not previously appointed.
Your Honor, will you repeat the bond amounts on the initial charges?
I don't know if I can remember.
1,000 on both.
Thank
1,000
you.
and 1,000.
Thank you.
Okay, who is this on? This is on Rosa? FTA warrant issued for that case and bond has already been discharged. Okay, he's on a no bond, so what do they want me to do? Need an amended order. Cannot be revoked because bond has already been discharged and a warrant issued. Okay. Oh, out of Orange County. Okay, I remember that case. Okay. Then we can withdraw the court's order, but I don't want to withdraw the capious warrant. Yeah. Can we just have the court minutes reflect that Mr. Rosa is already, there's the active warrant for Mr. Rosa. Thanks. Mr. Santos?
How you doing, Your Honor?
I'm well, thanks, Mr. Santos. Mr. Santos, you were with us based on an allegation of battery, domestic violence. I took a look at the charging affidavit. Do find probable cause. Court is going to set a bond in your case, appoint the Office of the Public Defender to represent you. Bond is going to be set in the amount of $2,500 with the following conditions. You are not to have any contact with Julie Beth Falcon. Ms. Lampier, do you want to ask your client whether they cohabitate?
All right, Judge. So the issue is that Ms. Falcon and Mr. Santos do not live or reside in Florida. They're both from Springfield, Massachusetts, and apparently they're taking a flight back on Tuesday to go home. They do not live together in Massachusetts, though.
All right. Officer Thomas, have we had any contact from the alleged victim? State, any input for the court?
The state has concerns for the victim's safety. We would be asking for no contact and separate residences. I understand that there is a flight and that they likely have to fly back to Massachusetts together. Perhaps defense could ask if there's any way seats could be arranged or flight times could be changed. Or maybe she's even already flown back.
All right. Mr. Santos, I don't have any input at all from the alleged victim. The court is going to order no contact. The court will allow incidental contact by simply being on the same airplane. But you're not to have a conversation about the facts of this case or anything. You're not to have a conversation at all. So whatever you can do to avoid contact with her while this case is getting sorted out, but I don't think it's reasonable to bar you from getting on the flight. When you return home, you are to maintain separate residences as a condition of your bond. You understand? Logo on this morning. State of Florida versus Stephen Burke. Is it Stephen or Stephen?
Stephen.
Stephen. Mr. Burke, good morning. Mr. Burke, you are here with us based on an allegation of battery domestic violence related. Took a look at the charging affidavit and do find that there is probable cause, at least for your initial arrest. Court is going to find that you qualify for pretrial release. I see no prior criminal history whatsoever. Court's going to release you on straight pretrial release with these special conditions. At this point, you are not to have contact with the alleged victim in this case. Anyone?
Rachel Aponte.
Thank you. Did I miss it? So you're not to have any contact with Rachel Aponte. You won't be able to go back to the Cason Cove Drive while this case is getting sorted out. Ms. Lanfear, do you want to ask your client whether they have personal property there?
Yes, Your Honor, he does reside there. We would request a one-time return with law enforcement.
Allow you to return one time, Mr. Burke, with law enforcement to get some personal property while this case is getting sorted out. Good luck. No, return. Return one time with law enforcement.
Another question.
Yes, ma'am.
He indicated that he resides there, but that she is going to be leaving to go live with her mother. If that's the case, would he be able to reside in this, in their shared residence if she's no longer living there?
Yes, if pretrial release determines that the alleged victim is not present in the home, he will be allowed to return.
Your Honor, so can we just change the bond condition from a no return to a separate residence then?
Court will amend the bond condition to that they are to maintain separate residences. And pretrial release may verify that she's no longer in the residence. Maxon Cezalian? Pronounce your last name for me. Pronounce your last name for me.
Sicilian,
Cecilian.
yes.
So Cecilian, you are here with us based on an allegation of battery, domestic violence related. That was pursuant to a warrant. Judge Walker has already found probable cause for your initial arrest. Court's going to set bond in your case in the amount of $1,000. I don't have a face sheet for Mr. Thank you. So it's going to be $1,000. At this point, you're to have no contact whatsoever with the alleged victim pursuant to Judge Walker's warrant, and you are not to possess any weapons or firearms. Thank you.
You have to contact the bond. Probably can, you just have to ask them.
State of Florida versus Michael Gray. Good morning, ma'am. We're going to place you under oath.
Raise your right hand. Do you swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you state your name for the record?
Linda Marie Gray.
Okay, put your hand down.
Ms. Gray, good morning. The court is going to make a probable cause determination as to the allegations against your husband, Michael Gray. Then I am going to consider conditions of bond for his release. Some of those conditions may include whether contact is appropriate between you and Mr. Gray and whether you wish to continue to reside with Mr. Gray and have contact with him. Do you wish to give me some information?
We moved from New Hampshire
Yes, ma'am.
a little more than a month ago, and he's been under an extreme amount of stress, as as I have as my mother, and we also have a 5-year-old son together.
Yes, ma'am.
What happened in the last 2 days was not his fault. And I don't fear my husband. We've been married 8 years. I love him. His son needs him. And I want him home.
Let me ask you some questions. So you've testified that you do not have any fear of further acts of alleged domestic violence for you or anyone in the household, is that correct?
Absolutely.
Do you have a cell phone or a means of communication should you have a concern?
Yes.
Have there been past acts of domestic violence?
Never.
And would it be your wish to have Mr. Gray return to the family home?
Yes.
Right, thank you. Ms. Lampier, any follow-up questions?
No, Your Honor.
Ms. Tyner, any questions?
No questions, but I do have some concerns. I, just based off the affidavit, I appreciate your testimony today here, but it is my concern that the victim feels that this is partially her fault. I would at very least be asking for no hostile contact. And I just want to make it clear that that's not a reason to want someone home.
Thank you. Ms. Gray, were you successful in getting a new phone?
Yes.
All right, thank you. Mr. Gray, I have taken a look at the document. I have made a probable cause determination, which is pretty low threshold for your initial arrest. You do qualify for pretrial release. I see no prior criminal history here in Florida, and the state of Florida is not aware of any out-of-state convictions that the court can make some determinations. I am going to release you on straight pretrial release with the following conditions. You're to have no hostile contact with your wife. That means no more arguments, no more, you may not put your hands on her without her permission, no sending threatening or confrontational text messages through social media or any other means. Do you understand?
Yes, sir.
Based on the sworn testimony of Ms. Gray, the court will allow you to return to the family home, and I will appoint the Office of the Public Defender to represent your interests. Thank you, sir. State of Florida versus Marnisha Johnson. Morning, Ms. Johnson.
Good morning.
Good morning, ma'am.
Good morning.
If you will please follow the clerk's instructions.
Raise your right hand. You swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Can you state your name for the record?
Irene Johnson.
All right, Ms. Johnson, you are listed as the victim. The defendant, Ms. Marnisha Johnson, is your sister, correct?
Yes.
All right, thank you. You've seen that I will be making a determination as to whether there is probable cause for the initial arrest. Then I will be considering issues of bond, including contact and return to the family home. Do you wish to give me any information about that?
No.
No? All right, thank you. Do you wish to have contact at this time with your sister, Ms. Johnson?
Yes.
And do you have any fear of Ms. Johnson and further acts of domestic violence?
No.
Do you have a means of communication if you did have some concerns?
Yes.
Do you cohabitate? Do you live in the same house as Ms. Johnson?
Yes.
All right. Do you have any objections to Ms. Johnson being allowed to return into the family home?
No.
Have there been any acts of violence in the past?
No.
Thank you. Ms. Lampier, any follow-up questions?
No, Your Honor.
Ms. Tyner?
No, Your Honor.
Ms. Johnson, I do find probable cause for your initial arrest. I don't believe that you qualify for pretrial.
I think she does, Your Honor.
She does? I'm going to release you on straight pretrial release. State, what's this conviction history indicates no felonies, but history is,
I have
indicates a
Florida
conviction for violent
conviction
crimes.
history for aggravated assault with a deadly weapon ×2, kidnapping, aggravated assault with a deadly weapon, domestic violence, aggravated battery, deadly weapon ×2.
You showing that those were convictions in the state of Florida?
Yes, that's what I have. I have the last conviction was in 2017 for criminal mischief property damage.
Wonder if that was as a juvenile.
Yeah, I think this might have was supposed to be arrest history, not conviction, but it does say conviction history on the sheet. But regardless, the last conviction was November of 2017.
Thank you. All right, based on this set of circumstances and these facts, court is going to release Ms. Johnson on straight pretrial release with the following conditions of pretrial release. You're to have no hostile contact with your sister. That means no more fighting, don't get in her face, no more verbal arguments. You can't send threatening text messages through social media or electronically. Do you understand?
Yes, sir.
Court will allow you to return to the family home. Thank you.
Yeah, it looks like all those cases were no information notice, Your Honor. I just looked them up.
Thank you, Ms. Lampier.
Thank you.
Yeah, of course.
Mr. Kennedy,
Yes, sir.
good morning.
Good morning.
Mr. Kennedy, you are here based on an allegation of battery domestic violence. I have taken a look at the charging document, and I do find probable cause for your initial arrest. I will appoint the Office of the Public Defender to represent your interests. Court is going to set a bond in the amount of $1,000. As a condition of your bond, you are not to have any contact with your daughter while this gets sorted out. You're also not going to be allowed to return to the location where this occurred, which is the Majestic Woods address. I have appointed the Office of the Public Defender. Ms. Lampier, do you wish to ask whether he has any personal property there?
Judge, it's his house, and she does not live there. So if she does not live there, we would ask that he be allowed to return.
All right, she's a minor. I'm a little bit concerned, but the court will order separate residences. I've got no way to verify that whether she's there or not. He's not on pretrial release. Officer Thomas, has there been any contact with the alleged victim's family? Yeah, I just don't have any information. So at this point, it's going to be no contact. Or no return to the property. I have appointed the Office of the Public Defender, and if there's additional information that you can show your trial judge, they may be able to amend that order. I will allow you to return one time with law enforcement to get some personal property while this is getting sorted out. No contact, no return. State of Florida versus Gilbert Martinez. Mr. Martinez, you are here based on an allegation of battery, domestic violence related. I have taken a look at the charging affidavit. Do find a probable cause for your initial arrest. Show no prior convictions. But based on the information, you do not qualify for pretrial release. Court's going to set bond in your case in the amount of $500 plus the following conditions of bond. You're not to have any contact with Michael Maxwell. We'll appoint the Office of the Public Defender to represent you. Ms. Lampier, do you want to ask whether they cohabitate?
Your Honor, they were on vacation down here, and they live in New Hampshire.
Okay. For the time being, it's going to be no contact and maintain separate residences. If the trial judge gets additional information, they can make a determination from that additional information as to whether an amendment of that order is appropriate. But as a condition of your bond, you're not to have any contact with Mr. Maxwell while this is getting sorted out. You understand?
I do. Yes,
Thank
sir.
you. All right.
Fine.
State of Florida versus Tatiana Martinez. Good morning, sir.
Morning.
Sir, please follow the clerk's instructions.
Please raise your right hand. You swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record.
Suni Felipa.
I'm having a tough time hearing you. Could you speak?
Suni Felipa.
Now I can hear you. Thank you. Mr. Felipa, you are listed as the alleged victim in the charging affidavit. As you've seen, I'll make a probable cause determination. Then I will consider reasonable conditions of bond. That will include whether you wish to have contact with Ms. Martinez and whether, if you reside together, whether you wish to have her return to your home. Do you wish to give me some information about those decisions?
No.
No? All right, thanks. Do you wish to have any contact with Ms. Martinez at this point?
Yes.
All right. And do you and Ms. Martinez reside in the same apartment?
Yes.
Is that the Sand Lake Sound Road apartment?
Yes, sir.
Do you wish to have Ms. Martinez return to that home?
Yes.
Have there been any incidents of domestic violence in the past?
No.
Do you have a means of communication if you have a concern,
Yes.
like a cell phone?
Mhm.
Was this issue alcohol or drug related?
No.
Okay, you guys weren't out drinking?
No.
Any minor children in the home?
Yes.
All right, thank you. Any concerns about your welfare or the welfare of the children if Ms. Martinez is allowed back into the home?
No.
Is that a no?
No, I said no.
Thank you.
Of course.
Any follow-up questions, Ms. Lampier?
No, Your Honor, I would just ask that you consider his answers in terms of the out on bond case as well. She's out on bond in the case.
I just have a quick question. Are you wishing to press charges and testify in this case?
No. No, absolutely.
Okay. Thank you, Your Honor.
Thank you. All right, the court does find probable cause for the arrest based on the sworn testimony of the alleged victim in this case and taking into consideration the facts of this particular case. The court is going to set a bond. That bond is going to be set in the amount of $1,000. As a condition of that bond, Ms. Martinez is to have no hostile contact with Mr. Felipa. No hostile contact, Ms. Martinez, means exactly what it sounds like. Cannot put your hands on him without his permission. No more verbal arguments, no more fights. And you may not be aggressive or send threatening text messages through electronic means or social media. Do you understand? You'll be allowed to return into the family home. I see that you are out on bond on a driving while license suspended charge. I'm going to take no action as to that charge.
Thank you.
So you will remain out on bond on that case. You'll be noticed when and if the state of Florida makes a filing determination and if formal charges are brought. Thank you.
Thank you, Your Honor.
State of Florida versus Tamarcus Reynolds. We'll see Mr. Reynolds tomorrow. State of Florida versus Andrew Salter. Good morning, Mr. Salter. Mr. Salter, you are here with us based on an allegation of domestic violence, battery. The court has reviewed the charging affidavit, and based on the information in it, I do find probable cause for your initial arrest. Bond in your case is going to be set in the amount of $1,000 with the special condition that you have no contact whatsoever with Nala Henry and that you maintain separate residences from Nala Henry. I will appoint the Office of the Public Defender to represent your interest. Thank you. Mr. Somerville?
Say.
Good morning.
Okay.
Somerville, you are here based on an allegation of battery, domestic violence related. I've taken a look at the charging affidavit, and I do find probable cause. Court notes that you have no prior criminal history whatsoever. Court is going to appoint the Office of the Public Defender to represent your interests, release you on pretrial release. As a special condition of your pretrial release, you're to have no contact at this time with the alleged victim in the case. That would be Destiny Gonzalez. Madam Fear, do you wish to inquire as to whether they cohabitate? Thanks.
Yes, Your Honor, we would ask for a one-time return with law enforcement.
Court will allow a one-time return with law enforcement. Mr. Somerville, you are indicating your weekly income at the amount on your application, and do you have a child at home?
Yes, Judge.
All right, thank you. You make in excess of what the court can consider to be indigent for purposes of appointment of the Office of the Public Defender, so I'm going to withdraw that appointment. That's not going to affect your bond. You're still bondable, and you can talk to some of our local attorneys. If your financial circumstances change, you can petition the court to revisit that, but you may or may not need an attorney depending on what and if the state of Florida files formal charges against you.
Your Honor, that's PTR with a bond?
Just PTR, straight PTR.
Straight PTR. Okay, thank you.
He's got no prior criminal history, so straight PTR, no contact, no return, one time with law enforcement.
Thank you.
Mr. Albert? Thank you. We'll try Mr. Well, he's an out-of-county warrant. I guess I can't appoint the Office of the Public Defender, so we'll try again. No, it's a failure to appear. It's our case. Slamfair, if the court appointed, would you waive on Mr. Albert?
Yes, Your Honor.
Court's going to appoint the Office of the Public Defender if they were not previously appointed 2021 CF 15982. He has a warrant for failing to appear. He has a bond in the amount of $1,000. Mr. Anderson? Good morning, sir. All right. Mr. Anderson, you were arrested based on an allegation of aggravated battery upon a pregnant person. That was a probable cause order sometime around September 14th, 2022. The court in that case assigned a bond in the amount of $1,000. I've got no additional information about that warrant. I note that you are out on bond on another case, and that was 2020 MM 6128. I'll appoint the Office of the Public Defender. I'm not sure that the new offense violates.
Well, I saw when I looked up that case that it was actually returned to the state to perfect service. So I don't know that he's even been served.
I see that it is noted in my records as an open case, but that's all. Case number is 2020 MM 6128. Do you have any information on that one for me?
I'm looking now.
Okay.
Uh, 20 mm. 6128. Anderson. We have that there was an arraignment on that case on November 18th, 2020. And prior to that, it was designated return to state on the same day. So it was returned to state at arraignment, and he has not been served on that case.
Was that filed at large? Was that a PC? Or was that an arrest?
Typically, I don't think there was any action. I don't think they took any action. I think they just said you didn't perfect service.
Okay,
So,
It's not a warrant, Your Honor.
yeah.
He would just have to show up to arraignment.
understood. I can't find that he's violated any conditions of his release in 2020 MM 6128. I am a little bit concerned about the probable cause order and the bond amount. State 2022 CF 10525. Is there a victim alleged in that case, and can you find out who that person is?
22 CS.
105.
Yeah, it's 2022 CF 10525. Officer Thomas, was this case worked up through pretrial release? No, was it worked up? I didn't have a face sheet for him. I didn't have a face sheet for this case.
Our office did make contact with the victim, and it appears that these charges were filed on September 9th of this year. So the case was filed on September 9th of this month, and it is still open.
All right. Can you give me a name of a victim?
The victim's name is Tanisha Walters, Tonisha, and then Walters is common spelling.
Mr. Anderson, you will have a bond on the new law offense. It's already been determined by another judge in the amount of $1,000. I'm going to add the special condition that you not have any contact with Tanisha Walters. I'm going to take no action on 2020 MM 6128 as that case has not been initiated at this time. Yes, sir. State of Florida versus Joseph Basden. Mr. Basden, good morning. You were arrested based on an allegation of open container.
Yes, sir. I did not ask for the public defender's assistance in this case. I asked to defend myself. I also asked that I be able to file criminal charges of assault on this arresting officer. And also in this affidavit that he wrote, that he admitted himself that he did not even create any kind of dialogue with me to even attempt to arrest me, and that he said it was an open container. It's visually seen on through cameras that the beer was closed, and or how should you say sealed? Because I sealed it myself with a knitted cap. I twisted it into the beer so that it would not come out, and it stuck out about 8 inches long, and it was red. And I was walking with it in my hand, and it was sealed, and the rag was hanging out of the beer. Impossible for me to drink. And I set that down when he addressed me. After that, he began to touch me, grab me, and say nothing to me. So I defend myself and get him off me until he explained why his hands were on me. The same way that it is written inside this report. He didn't address me, say he was trying to arrest me. He just began to grab me. Now, under the circumstances, I'm a man, he's a man. I don't know what his intent is. And the police, in not good conscience, in these days, should be grabbing people without at least letting them know why. So I could have time to figure it out. He didn't give me time to figure it out. He began to assault me without even addressing me, or touching me without even addressing me. And then later on, 2 or 3 times I've been stopped by the OPD. In this year, I have ended up in the hospital before being brought to jail.
Right.
The same situation.
All your statements are captioned for the record. I think you overestimate what the court's power is. I don't bring criminal charges against anybody. That's the state of Florida that brings those charges. My job this morning is to take a look at the charging affidavit and make a couple of determinations. The first determination I have to make is pursuant to the case law, I have to presume, because I wasn't there, that the allegations in the charging affidavit are true, and if they are true, whether there establishes probable cause for a criminal offense. I will not appoint the Office of the Public Defender. If you don't want the Public Defender, that'll be a discussion that you'll have with your trial judge. There's a lengthy discussion called the Feretta Inquiry that they'll need to go through with you to verify that you're competent to represent yourself. I can see that you're a good advocate for your position. I got no concerns about that, but that's a discussion for another day. So my job today is to make a determination as to whether there's probable cause for your initial arrest. I do find that there's probable cause. I'm going to grant you a bond, and your bond is going to be set in the amount of $150. I will not appoint the Office of the Public Defender at your request. Unfortunately, you are out on bond on another case. You're on ROR on a resisting an officer without violence. You're on bond for a tampering with physical evidence and possession of drug paraphernalia. I'm not sure when the court saw you on those cases. Those facts sound familiar.
This month, I went to court on that.
Yeah, sounds from. Based on this law offense, I'm not going to take any action on that case. 2020.
Your Honor.
Go ahead.
He also has a battery on law enforcement and a resisting officer with violence here today. I believe that's why he's in the felony section and not pleables.
I missed it. All right, also assuming that what's in the affidavit is true and correct, there is probable cause for the allegations of battery on a law enforcement officer and resisting an officer with violence. Bonds on that case is going to be set in the amount of $2,500, and is to count 2. I think that's somewhat of a duplicative charge, so that will be ROR'd. So you have a bond in the amount of $2,500. You have a bond in the amount of $250 as to the open container. You're ROR'd as to the resisting an officer with violence. That changes the calculus a little bit because you're out on felony bond on a felony offense, and there's probable cause to believe that a new felony offense was committed while you're out on bond. So I'm going to revoke your bond in 2022 CF 7297. You are free to request bond through your trial attorney, but at this point your bond's going to be set in the amount of none. So you got no bond on 2022 CF 7297, and if you want to make your pitch to your trial judge, they may consider setting a bond based on these circumstances. Does the Public Defender's Office represent Mr. Basden on the old case?
I believe so, Your Honor.
Okay. Mr. Basden, you're already represented on the other case. They can get you in front of the judge at least probably faster than you can. So good luck to you, sir. Caleb Bidall? Ms. Bidall, good morning. You are here based on an allegation of possessing methamphetamine. The court finds probable cause. I'll appoint the Office of the Public Defender, and your bond set in the amount of $1,000. Thanks. State of Florida versus Anthony Coleman. Good afternoon, Mr. Coleman. Mr. Coleman, you are here based on an allegation of possession of a concealed weapon by a convicted felon and possession of MDMA. I do find I find probable cause for those initial arrests. You will get a bond in counts 1 and 2. Your bond is set in the amount of $4,000 to count 1. $1,000 is to count 2, and I'll appoint the Office of the Public Defender to represent your interests. As a special condition of your bond, you're not to possess any weapons or firearms. Thank you. State of Florida versus Jaime Cruz. Mr. Cruz, good afternoon.
Good afternoon, Your Honor.
Mr. Cruz, you are with us based on an allegation of possession of methamphetamine. Court finds probable cause for that allegation. Mr. Cruz qualifies for,
Empty.
hold on just a sec. You make the, I'm going to appoint the Office of the Public Defender to represent your interests. You'll make them nervous if you want to talk to me about the facts of the case. It's probably best to talk to them first. I will find that you qualify for pretrial release you on pretrial release with the special condition of pretrial release that you not possess or consume any illegal substances. Thank you.
Your Honor, can we have random urinalysis added?
Does he have a history?
Well, he's picked up for meth.
Does he have a recent history? Last conviction, 6-7? Yeah, I'm going to add random drug testing, Mr. Cruz, to monitor that you're complying with the court order. Thanks. State of Florida versus Jamaris Fountain. Mr. Fountain, good afternoon. Sir, you were arrested based on allegations of carrying a concealed firearm and resisting an officer without violence. I do find probable cause for both of those allegations. Bonds are going to be stayed in their current amounts in the amount of $2,500 and $100 as to count 2, and I'll appoint the Office of the Public Defender. As a special condition of your bond, you are not to possess any firearms. Thank you. State of Florida versus Brittany Garcia. Ms. Garcia, good afternoon. Ms. Garcia, you are here with us based on an arrest from a warrant. The warrant alleges grand theft by fraud, burglary of a dwelling, and uttering a forgery. Bonding count 1 is set in the amount of $5,000, count 2 in the amount of $5,000, count 3 in the amount of $2,500 for a total bond amount of $12,500. As a condition of that bond pursuant to my warrant, you're not to return to the property and have no contact with the alleged victim. I'll appoint the Office of the Public Defender to represent you. Thanks. State of Florida versus Patrice Goodwin. Good afternoon. You were arrested based on an allegation of possessing MDMA or ecstasy or methamphetamine, I can't tell which, a controlled substance. I find probable cause. You have a bond in the amount of $1,000, and I'll appoint the Office of the Public Defender to represent you. Thanks. State of Florida versus Anthony Grooms. Mr. Grooms, good afternoon. All right. Mr. Grooms, you were arrested based on an allegation of driving while license suspended. I took a look at the charging affidavit. I do find probable cause for your initial arrest. The good news is that you qualify for pretrial release. I'll release you on pretrial release with the special condition that you are not to drive without a valid driver's license and that you are to possess no weapons or firearms while you are on pretrial release. Looks like based on your affidavit, you make an excess of what the court can consider as indigent, so you need to talk to some local attorneys if you decide to engage an attorney. Thank you. Good luck. State of Florida versus Brandon Jagdeo. Did I get close?
Pardon?
Did I get close on the name? Is it Jagdeo?
You did it exactly correct.
Mr. Jagdeo, good afternoon.
Good afternoon.
You are here based on my warrant. That warrant alleged counts of robbery, aggravated assault with a deadly weapon, and petty theft for that issue at the 7-Eleven. I've already found probable cause and assigned bonds in your cases in those counts. Bond is count 1 is the amount of $7,500. Count 2 in the amount of $2,500, and count 3 in the amount of $250. I will appoint the Office of the Public Defender on the new case. Unfortunately, you're out on a grand theft charge on bond, and I have probable cause to believe you have violated the law where you're out on bond. I'm going to revoke your bond in 2022 CF 1265, so you're going to remain with us on no bond until you can get in front of your trial judge, let them know what's going on. I'll appoint the Office of the Public Defender on that case as well. Thanks. State of Florida versus Porcina Joaquin. Is that close?
It was close.
Tell me your name, please.
Porcina and Josham.
Mr. Josham, thank you. Mr. Josham, you are here based on an allegation of aggravated assault with a firearm. Based on the information in the affidavit, I do find probable cause. I will set a bond in your case in the amount of $5,000. As a special condition of that bond, you're not to possess any weapons or firearms. Based on your sworn responses, you make in excess of what the court can consider to be indigent. So I'm not going to appoint the Office of the Public Defender. You'll need to talk to some of our local attorneys if you wish to be represented.
Okay, I'm still confused a little bit, but I said I'm still confused a little bit.
Let me caution you that I know you want to talk to me about the allegations and you may disagree with what's in the charging affidavit. You're being recorded, and I don't want you to make any statements that will put you in a worse position. You don't have an attorney at this point, so I'd prefer that you not talk to me about the facts of the case. I'm not going to shut you down if you insist on talking to me, but that would be the advice that your attorney would give you if one had been appointed.
No, it's cool because the officers there searched my vehicle and they have seen no firearm in there. There was a phone in my hand.
Take a quick look. I don't know what the state of Florida will ultimately decide to charge, if anything. The victim in the case, or the alleged victim in the case, indicated that they observed a firearm and observed presumably you cocked the gun. I don't know whether they'll be able to prove that or not, but based on what's in the charging affidavit, I've made a probable cause determination. So you do have a bond, and defenses and are something to discuss with an attorney or the court when and if formal charges are filed.
Your Honor, are you issuing a no contact with the victim?
I don't think these people knew each other, but I'll throw
Okay.
that
No,
throw that on there, that he's not to have any contact with the alleged victim.
thank you.
Thanks. State of Florida versus Nicole Johnson. Ms. Johnson, good afternoon. You were arrested based on allegations of possessing methamphetamine, possessing drug paraphernalia. I do find probable cause. Bonds in count 1 is going to be set in the amount of $1,000, count 2 in the amount of $100, and I'll appoint the Office of the Public Defender. Thanks. State of Florida versus Katrina Jones. Thank you. State of Florida versus Mallory Kinchen. Good afternoon. Mr. Kinchen, you are here with us based on an allegation of a new law offense. That offense is possession of methamphetamine, MDMA, or ecstasy, and resisting an officer without violence. Just a sec. Based on a reading of the affidavit, I do find probable cause for your arrest. We'll set bond in the new case and count 1 in the amount of $1,000, count 2 in the amount of $100, and appoint the Office of the Public Defender. Bad news is that you were out on bond on a serious trafficking offense in 2022 CF 9406. Court finds probable cause to believe that you have violated the law while out on bond. Your bond in that case is going to be revoked and set at none. I'll appoint the Office of the Public Defender on that case if they didn't previously represent you. Thanks. Got no bond on the old case. Bernard Norris. Defense, what would you like to do with Mr. Norris?
We'd like to reset his case, Your
We'll
Honor.
reset Mr. Norris. State of Florida versus Byron Robinson. Mr. Robinson, good afternoon. You're here with us based on an allegation of robbery. I have read the charging affidavit, and I do find probable cause for that initial arrest. I'm going to set bond in this case in the amount of $5,000. That bond is stayed. You're not to have any contact whatsoever with Terrence Norman.
Yes, Your Honor.
And I'll appoint the Office of the Public Defender to represent your interests. As a special condition of your bond, you're not to possess any weapons or firearms. Thank you, sir. State of Florida versus Lindsay Sanders.
Hello, Your Honor.
Mr. Sanders? Mr. Sanders, you are here based on an allegation of grand theft, third degree of a motor vehicle.
At most, $15 I might pay for it. $3 was the top miles per hour. 3 miles per hour was the top speed. Nobody touched it in at least a year. They got it back. I'll replenish the gas, maybe $5 worth.
All right, Mr. Sanders, I understand that you think you may have some defenses to the allegation of grand theft. I don't want you to make any statements that are going to put you in a worse position. I find probable cause based on what's in the charging affidavit. I am going to set a bond in your case. Your bond's going to be set in the amount of $500, and I'll appoint the Office of the Public Defender to represent your interests.
Okay. What happened to the golden rule, where every man's God-given and inalienable right to pursue happiness? I was in the middle of an orange field covered with sand spurs, barefooted, with feet that hurt beyond your ever touching in a nightmare. You would have stole it too.
I'm sorry to hear that you were having a tough time. I wish you luck. Thank you, sir. Mr. Stevenson? Are you Mr. Stevenson? Good morning. Good afternoon. Yeah, it feels like tomorrow. Mr. Stevenson, you are here based on a number of offenses. You got a new law offense. That is a possession of methamphetamine. It says MDMA or ecstasy for something alleged to have happened yesterday. I took a look at the charging affidavit and do find probable cause for that arrest. You also have a failure to appear warrant out for missing court. Looks like there was no valid driver's license court hearing that you missed. The court did set a bond in that case in the amount of $500. Unfortunately, you're out on bond on a couple other cases. That's 2022 CT 1994 and 2022 CF 4019. I have probable cause to believe that you violated the law while you're out on bond on those cases. I'm going to revoke your bond in those cases, set bond the amount of none. You can have your attorney get you in front of the trial judge, see if you can explain to them what's going on. But at this point, it's going to be no bond, and I'll appoint the Office of the Public Defender on all your cases. That's the new law offense I did. I set a bond the amount of $1,000. So you got bonds on the old cases. You got bonds on the new cases. You got a bond on the failure to appear. I revoked your bond on the old cases. State of Florida versus Timothy Stovall.
Refusal.
Lampier, you want to waive? He's a failure to appear.
Yeah, that's fine, Your Honor. We'll wait.
Mr. Stovall will be appointed the Office of the Public Defender if not previously appointed. I suspect they were already representing him on the other case. I'll accept a waiver of his appearance. He is on a warrant for allegedly failing to appear on September 7th, 2022. Judge set no bond based on that bench warrant. He'll remain at no bond. Thank you. State of Florida versus Timothy Taylor. Okay. He's got a new felony offense and he's out on bond on 2 other cases. What would you like to do, Mrs. Lampier?
Well, let's reset him, Your Honor.
We'll reset Mr. Taylor's case till tomorrow. Squan Turman. Pronounce your name for me. Saquon. Mr. Turman. Good afternoon, Mr. Turman. Mr. Turman, you were arrested based on allegations of possession of a concealed firearm by a convicted felon, possession of ammunition by a convicted felon, possession of cannabis with intent to sell or deliver with a weapon, possession of cannabis over 20 grams with a weapon. Court does find probable cause based on what's in your charging affidavit for your initial arrest. Bond in count 1 is going to be set and stayed in the amount of $5,000. Bond in count 2 is going to be stayed in the amount of $5,000. Bond in count 3 is going to be set in the amount of $15,000. And I'm going to ROR finding that this is a duplicative charge as to count 4. So total bond amount is $20,000. As a special condition of your bond, you're not to possess any weapons or firearms. You're not to possess or consume any illegal substances. And the Office of the Public Defender is appointed on these cases. Thanks. State of Florida versus Elijah Thomas. Got a bond. Ms. Lampier, what would the defense like to do?
Yes, Your Honor, we'll waive.
Court's going to accept the waiver, appoint the Office of the Public Defender in 2022 MM 3901 if not previously appointed. He's here for a failure to appear pretrial conference September 8th. He has a bond amount in the amount of $3,000. State of Florida versus Philippe Popgrave.
We'll waive, Your Honor.
No, I need to see Mr. Popgrave. We'll reset. State of Florida versus Robert Blackwood. Thanks.
And Mr. Blackwood indicated he'd like to take a plea in this case, Your Honor.
He's out on bond on a couple of things, so.
It looks like, at least on the 2021 CF 9034, it was a PTD case. I don't know if he's out on any other cases.
Oh, he's in PTD. Mr. Blackwood, good afternoon. Mr. Blackwood, you are here with us based on an allegation of trespass. And take a quick look. Looks to the court that you were just trying to find a place to sleep. I will consider a resolution this morning. Let's hold on to Mr. Blackwood and we'll do the pleas at the end.
Yes, Judge. If we could address Mr. Goff. He's still in chains. He was we're gonna wait till the end to have him, but
Yes.
he's still in chains. So he's waiting there.
Mr. Goff, who we had in chains, you said to do him at the end?
Yeah. Why is he in chains?
He was in chains when he came in, for his housing. He's in mental health housing.
Okay.
Typically don't keep them in chains that long. So
Oh,
For his comfort, I guess.
for us, it's a lot.
all right. Thank you. I'm happy to take him early. Have you had a chance to talk with Mr. Goff?
I talked with him earlier, Your Honor. He did indicate he wanted to take the plea that was offered by the state.
If he's still high as a kite, I'm not sure that I'm going to be able to find him competent to accept a plea, or if there's a mental health concern.
Yeah, I believe it might be mental health, Your Honor. We
Okay.
would just ask for.
Okay. We'll take a look.
Your Honor, the offer is a withhold.
Mr. Goff, good afternoon. Please follow the clerk's instructions.
Raise your right hand. Do you swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yeah.
Can you state your name for the record?
Thank you. Mr. Goff, you can put your hands down. Mr. Goff, your attorney tells me that you want to enter a plea this morning to your allegation. That is an allegation of trespass in an occupied structure or conveyance. Is that what you wish to do?
Is that what you want to do? You want to plead today?
Can she speak for me, please?
Can she speak for you?
Yes, please.
No, I got to make some determinations as to whether you're with me and whether you're understanding what we're doing.
I'm sorry.
So, oh, that's all right. I'm not admonishing you. I'm just telling you that that's how it works. So we'll have a discussion about the rights that you'd be given up if the court accepts a plea this morning. And then I'll make a determination as to whether I'm satisfied that you understand everything. And I don't have a problem with the anticipated resolution. So if you'll stick with me for just a minute and answer my questions, that'll help me make those decisions. What has been told to me is that you want to enter a plea of, and I'll accept a plea of no contest. That means I don't admit or deny the offense, but I'm not contesting them, and I would listen to the state, and they would make a recommendation to me as to what sentence. I suspect the recommendation is going to be a withhold of adjudication, and I sentence you to the time that you'd already served. After that, then you would owe some court costs. With the understanding that that's probably what the sentence would be imposed against you, do you wish to plead no contest to the charge of trespass?
Yes, Your Honor.
Do you understand that even as to that charge, you have a right to have a jury trial? And at that jury trial, the state of Florida would have to prove to a jury, beyond and to the exclusion of every reasonable doubt, you committed each offense that you were charged with. You would have an attorney with you at a trial. They would be talking to the witnesses, looking at the evidence. You could have presented your own witnesses and evidence. You could have spoke at your trial, or you could have remained silent. You could have had your trial tape recorded and appealed any error that occurred in that process. Do you understand, if I accept your plea of no contest this morning, you're giving up all of your trial rights, because I'm just going to sentence you to what the state is asking for, and we won't be having a trial in this matter. Do you understand those things?
Yes.
Is anyone forcing you or pressuring you into making this decision?
No, Your Honor.
Has anyone made you any promises other than what we just talked about?
No, Your Honor.
Are you under the influence of any alcohol or drugs at this time?
Tobacco.
Tobacco? Do you think that the tobacco use is affecting the way that you are thinking right now? Or you feel you're thinking clearly?
Yes, I do, Your Honor.
You think it's affecting your ability to think clearly?
No.
Okay, so you think you're thinking clearly here today. Do you see any doctors for any mental health issues?
Yes, I do.
Okay. Have they prescribed any medications for you?
Yes, they have. At least lorazepam.
Do you take those?
I do.
Do you take them at the level that is prescribed by your doctor?
I do.
Okay, when was the last time you took your meds?
Last night.
Last night? You got them here at the jail? Do you think that they are,
No, Your Honor.
oh, you did not get them here? at the-
No, I did not, and that was the big problem I was having. I didn't sleep last night. I've been off of I live at summertime ELF,
909 North Wymore Road, Winter Park, Florida, 32789.
Okay.
And I'm mentally ill. I don't know my diagnosis because they kind of protect me there from asking questions that don't belong to my own knowledge.
I understand.
They have my psychiatrist there. They have my medical doctor there. They just give me my medicine.
Do they know you're here in the jail?
No, they don't. And I've been trying to reach them, but I can't reach them.
Okay. Well, I've appointed an attorney for you. So I'm going to ask the attorney to reach out, and if you'll give her that contact information, she'll make a call and let them know to come get you if and when you're released from here.
Yes, please.
Would that help you?
Yes, it would, Your Honor.
All right. So my question is, even though you haven't got your medications today, do you think that you're thinking clearly enough to make a decision as to resolving this case?
No, I don't. I need my medications, Your Honor.
Okay.
Your Honor.
I have insomnia and weird stuff, hallucinations, all kinds of stuff.
Given the testimony today and the concerns for competency, I would not object to an ROR of this individual.
All right. I'm concerned about letting you enter a plea to a criminal offense. Based on our discussions and based on the non-violent nature of what you're charged with, I'm going to release you on your own recognizance. I'm concerned that the jail's just going to process you and then walk you right out the front door. So what I want you to do before you leave is let Ms. Lamphere, who works for the Office of the Public Defender, know your ALF location. Do you know the telephone number there?
I think so, Your Honor.
Okay. She's going to make a call.
407
Hold on, just
5515, Your Honor.
645-5515?
Yes, Your
All
Honor.
right.
407 area code.
Repeat it one more
All
time.
right, so the
407 area code, I'm sorry.
say the ALF facility is, what's the name of it?
It says on the sign, Summertime Retirement Homes on 909 North Wymore Road, W-Y-M-O-R-E Road, Winter Park, Florida, 32789, off of Lee Road and Wymore Road near the Denny's.
Do you have a counselor or somebody there that you trust?
Yeah, I know Jay, I know Ray. Ray Happy can drive a van to pick me up.
Okay.
Ray can give me, he allows me to smoke cigarettes and drink soda pop, like Sam's Cola.
All right.
So smoking cigarettes is not without their knowledge.
Understood.
On a daily basis, there's a smoking lounge out back.
Okay.
That I signed out. The problem, why I landed here, Your Honor, is because I realized that it was too late for me to make it back, walking back home by curfew.
I understand.
Midnight every night.
I understand.
But curfew is between midnight and 6 a.m. I can't be off grounds, and I was too far away walking because of my faith in God.
And you don't have a cell phone, right?
I can't afford one anymore.
Okay.
I had one, and I ran out of money.
Ms. Lamphere, after court, would you share that telephone number with me? I'll make a call as well, and we'll double up, try and make sure that somebody comes and gets Mr. Goff when he's released.
64?
All right, Mr. Goff, you're going to be released today. We'll try and make some calls and let the ALF facility know that somebody needs to come get you, okay?
Thank you.
Yes, sir.
God bless your court.
You as well. Our next case is Marky Brown. Ms. Brown, you are with us based on a new allegation of resisting an officer without violence. Took a look at the charging affidavit. do find probable cause for at least the initial arrest, failing to comply with the officer's lawful commands. I will set a bond in the new law offense in the amount of $250. Unfortunately, you're out on bond on another felony case. That felony case is 2022 CF 8492. That's a fleeing and attempting to elude a law enforcement officer allegation. I have probable cause to believe you violated the law while you're out on felony bond. I'm going to revoke your bond in that case. Set bond in the amount of none. I'll appoint the Office of the Public Defender on both cases, and they'll be able to get you in front of your trial judge.
Your Honor, Mr. Brown asked if you would be willing to double the bond on the 2022 CF 8492 AO.
I understand Mr. Brown has some issues with the authority of the law enforcement officers. I completely understand that, but he's out on bond on a felony offense, and this is an offense. The charging affidavit alleges that he was doing twice the speed limit in a residential area and wouldn't follow the commands. I'm not super excited on the reason why he was pulled over, but I think revocation at this point, he can make that pitch to his trial judge. They may be receptive to it. Thanks.
You got to get your attorney to.
State of Florida versus Damian Davis. Okay. New drug case, out on bond on a drug case. Oh, he's ROR'd on a drug case. Ms. Lanfear, what would you like to do?
Could we reset him?
We'll reset Mr. Davis's case. Have a busy reset docket tomorrow. State of Florida versus Sean Deal. Thank you. How was he ROR'd? Did he bond or? Okay. I do see ROR on the paperwork. I don't know how that happened, but I guess he qualified.
Everybody gets lucky every now and then.
State of Florida versus Ernst Gonzalez.
Yes, sir. Yes, Your Honor.
Mr. Gonzalez, good afternoon.
Good afternoon.
Mr. Gonzalez is arrested for loitering and prowling. Mr. Gonzalez was found inside on private property, but he was in a portable restroom. I'm not sure I'm convinced that there's probable cause for loitering and prowling. State?
Based off the affidavit, the alleged defendant could not give any reason as to why he was supposed to be there or if he was allowed to be there. We believe that's why the charge was made, since he could not dispel the fears of prowling in a place at an unjustifiable time where a reasonable law-abiding citizen would not be. So based off that testimony of the officer, we contend that's why he was picked up on loitering and prowling.
Understood. He was there at 10:25. I don't find that to be a unreasonable time. He's in a going to find that there's insufficient evidence to establish probable cause. He'll be released on his own recognizance. Mr. Gonzalez, I wouldn't go back there if I were you, just because they'll be looking out for you, but I'm going to release you on your own recognizance. And I will appoint the Office of the Public Defender to represent you. I don't know whether the state will end up filing charges or not, but you will be released today. You understand?
Yes, Your Honor.
All right. Good luck.
Thank you.
State of Florida versus Quinzel Johnson.
Your Honor, I think that might have been the best argument I ever made.
Mr. Johnson, good afternoon.
Hey,
I'm good, thanks for asking. Mr. Johnson, you're here with us on a possession of cannabis under 20 grams offense. Court finds probable cause for that allegation. Your bond's going to be set in the amount of $250, and I'll appoint the office of the public defender. Hold on just a sec, Mr. Johnson, there's more.
Hang on. Wait.
Is he out on bond, or has that case been filed? Can you give us that case number one more time, Officer Thomas?
That case has filed charges as of the 9th of this month for possession of a controlled substance. And trying to see if he was already arraigned. I don't see anything as to the next court date, but there are charges filed.
Okay. But he's not out on a bond?
The bonds were issued for trafficking, possession, but there were 5 counts. We only filed charges on the possession of a controlled substance, and that was not one of the listed charges. So he is out on bond.
I got R&R.
You got ROR'd on that case, because 33 day?
I would assume so, yeah, because the original first count was from May.
It was a 33 day.
Yeah.
The offenses are what?
The only charge we filed is possession of a controlled substance.
All right, he was in the car with Mr. Turman, it looks like, and they only filed possession of cannabis under 20 grams regarding Mr. Johnson. On the old case, the court's going to revoke the ROR because I got probable cause to believe you were in possession of marijuana while you were out on some form of release. I'm going to set a bond in that case in the amount of $1,500. So you're bondable on both cases. As a special condition of the bond, you're not to possess any weapons or firearms.
And then,
Bond was $1,500. I'm being told there was only one count.
yes, only one charge was filed for possession of a controlled substance.
All other non-filed charges are ROR'd on that case. Just for clarity, so he's not held.
And then today was $250, correct?
Yes.
$250. Thanks. State of Florida versus Talandra Maxey. Ms. Maxey, good afternoon. You are here based on an allegation of battery. Court finds and a allegation of trespass on a property, not a structure or a conveyance. Find probable cause for both of those allegations. Bond's going to be set in both of those allegations in the amount of $500 for a total bond amount of $1,000. And I'll appoint the Office of the Public Defender to represent your interests. Those were filed separately in 2 separate cases, 2022 MM557 and 2022 MM558. Thank you. Yanni Roman? Sorry? Oh, thank you. Mr. Roman, good afternoon. Mr. Roman, you are here based on an allegation of trespass on a property after warning. I do find probable cause for your arrest. I'm going to reduce your bond down to $250 and appoint the Office of the Public Defender. Looks to me you're trying to find a place to sleep under a light. I'm going to take no action on 2022 MM 1888, which is an allegation of resisting an officer without violence. I'll appoint the Office of the Public Defender on both of your cases. State of Florida versus Kareem Williams. Williams, good afternoon.
Good afternoon.
You're here based on an allegation of trespass on a property after warning and resisting an officer without violence. Taking a look at the affidavit, do you find probable cause for that allegation? Bond is count one is going to be reduced to $250. Bond is to count two is going to be remain at $500, and I'll appoint the Office of the Public Defender to represent your interest.
Your Honor, sorry, I was just talking with Mr. Williams. There was an offer made to resolve both cases of a withhold court cost and credit for time served, and he indicated he would like to do that.
Let me take a quick look, see what. I take a quick peek, Officer Thomas, at sheet.
You don't have to resolve if you have defenses. You can either have a bond or you have bond.
We're not showing any criminal history, so sounds reasonable to me.
As a friend of the court, I would like to mention that if he does not have a criminal record, he is likely eligible for our pretrial diversion program. So you might want to take that into consideration.
Your Honor, he indicated he just wants to bond out today.
If you don't have a criminal record, I'd hate to see you get one from this incident. There may be some programs available to you that will keep this off your record. I think you ought to explore those. So you have a bond on both counts. Good luck.
So what's the bond? What's the bond?
$250.
It's $250 and $500. So total bond amount of $750.
$250 and $500. So you can contact anyone you need to.
So $750.
But if you go through a bondsman, it's 10%.
State of Florida versus Eric Gardner. Mr. Gardner, good afternoon. You're here with us based on an out-of-county warrant. That's out of Seminole County. The warrant, I'll give you as much information as I have. Warrant looks like a allegation of violation of probation on a controlled substance. Probation, Judge Gardner issued a warrant for you. That warrant unfortunately has no bond. You're going to remain on no bond until we can get you over Seminole County in front of Judge Gardner. And we'll let Seminole County know that you are here with us. Thanks. State of Florida versus Garman Muhammad. Good afternoon, sir.
Good afternoon.
You got a similar situation. You got an out-of-county warrant, but you have a bond. Your Polk County judge issued a bond in the amount of $500. The allegation was failing to appear for a possession of cannabis under 20 grams, possession of drug paraphernalia, and a violation of a financial responsibility and driving while license suspended charge in a number of cases. Your bond is set, well, it says 500, but I guess there's multiple bonds. It's 500 as to each of those cases for a total bond amount in the amount of $3,000. So you are bondable. Well, yeah, I see more than that. Yes, ma'am? Yeah, the total bond amount doesn't appear to be correct on my paperwork. Take a look.
I believe it's 500 on the violation of financial responsibility, 500 on the driving while license suspended, $1,000 on the cannabis, and $1,000 on the paraphernalia to equal 3,000 total, unless I'm missing a case, but.
Nope, I think that's correct. I misstated it. So $1,000 on count 1 of MM224320, possession of cannabis, $1,000 on the drug paraphernalia. The violation of financial responsibilities, 500, and the duelist with knowledge, 500. Total bond amount of $3,000. Thanks. We'll let Polk County know you're here with us. Larry Oliver. Mr. Oliver, good afternoon. You've got an out-of-county warrant. That's out of Seminole County. I'll give you as much information as I have. Case number's, looks like 21934 CFA. The allegation was violation of probation. The underlying offense was fleeing or attempting to elude a police officer. I don't have the judge's name, but the judge issued a warrant for your arrest. It's Judge Chase. That warrant unfortunately has no bond. You're going to remain on no bond until we can get you in front of Judge Chase. Seminole County will be advised that you're here with us. Thanks. State of Florida versus Brady Williams. Right. Mr. Williams has out-of-county warrants, 2,000, 2,000, 500, and 500. I'm going to find he's voluntarily absented himself from these proceedings. I'm not going to reset Mr. Williams. This will conclude his initial appearance. We'll let Broward County know he's here with us. State of Florida versus Lindsay Woods. Ms. Woods, good afternoon.
Good afternoon.
Ms. Woods, you are here based on out-of-county warrants, also out of. Let me see. The other day. Okay. Guess you know Mr. Williams?
I'm not bad though, like him.
Ms. Woods, unfortunately, you got the same warrant. That's warrant out of Brevard County. And you do have bonds. On count 1, your bond is set in the amount of $2,000. That's for a larceny grand theft over $100,000. Count 2 is illegal use of credit cards. That also has a bond in the amount of $2,000. Possession of a false ID, that has a bond of $500, and larceny of a credit card, also a bond in the amount of $500. So you are bondable.
5,000.
And we'll let Brevard County know that you're here with us. Thanks. State of Florida versus Elvin Caban.
Your Honor.
All right, that's the second refusal. Slamfear, what would you like to do?
I think we can waive, Your Honor. I do have a probable cause challenge.
We can't get, was Mr. Caban with us yesterday too?
He was a reset for refusal.
I hate to drag people here. court orders that he be brought by any means necessary tomorrow, including the use of reasonable force. Will the jail comply with that request? All right. He's got $1,000 bond. All right, the court's going to order that this is a third opportunity to allow Mr. Caban to participate in his initial appearance. He has a $1,000 bond. He is a refusal. Any additional information on the refusal? Just won't come, huh? All right, the court's going to order that he be brought to court tomorrow for IA by any means necessary, including the use of necessary force. Can we generate some court minutes that reflect that? I don't have any ability to generate a written order for you. We'll take him first tomorrow before Osceola County. State of Florida versus Anthony Dominguez.
I have a probable cause challenge on him, too. They don't want to hear my PC challenges? He refused yesterday as well, Judge.
I know. See the attorneys up here at the bench, please. We're going to readdress Elvin Caban, 2022 CF 1116. Court's going to withdraw its previous order to require Mr. Caban to be brought to court by any means necessary. The court's going to find his repeated refusal to attend initial appearance is an indication that he is voluntarily absenting himself from these proceedings and indicating a waiver of the necessity of his appearance. Court's going to appoint the Office of the Public Defender on his case. He's got a bond in the amount of $1,000.
Can I be heard as to the probable cause challenge?
Sure.
The only thing I'm arguing, Your Honor, is that this was filed as a petty theft to prior convictions, and within this affidavit, there's no allegation that he has 2 prior charges or convictions of petty theft.
Court finds probable cause of petty theft over $100 and bond set in the amount of $1,000.
Thank you, Your Honor.
State of Florida versus Anthony Dominguez, 2022 MM6496. Court finds that Mr. Dominguez has twice refused to come out of his cell and join us at initial appearance. I'm going to take that refusal as him voluntarily absenting himself from the proceedings and an indication to the court that he is not interested in his opportunity to be present at the time that he receives his initial appearance. I'll appoint the Office of the Public Defender to represent his interests. Ms. Lampier?
Yes, Your Honor. The probable cause challenge would be within the affidavit. There is no allegation. All it says basically is that he willfully resisted, but there's no allegation of any facts to determine what occurred or whether or not it would be resisting.
I agree.
State concedes to that argument.
Without additional information, the court cannot find probable cause of the allegation. He will be released on his own recognizance.
Thank you, Your Honor.
State of Florida versus William Matthews. Mr. Matthews will need to be reset if there's no waiver.
Yes, Your Honor. We'd ask to reset.
Mr. Matthews will be reset based on medical. State of State of Florida versus Quentin Rosier. Good afternoon, Mr. Rosier.
Good afternoon, sir.
Mr. Rosier, you're here with us based on an allegation that you violated your probation based on a alleged new law offense in case number 2022 CF 11154. That allegation is possessing cannabis over 20 grams. I've read the charging affidavit. I do find probable cause for your initial arrest. Bond in the new case is going to be set in the amount of $2,500. As to the probation case, the court has probable cause to believe that you have committed a new felony law offense while you are on probation. I'll give you the case number.
But I had
Hold on just a sec. Let me go through this and I'll hear you out. The case number is 2018-17683. Court's going to find an on-view violation of probation. You're going to have no bond on the VOP. I'm going to appoint the Office of the Public Defender. Whatever you wanted to tell me, why don't you tell Ms. Lampier, and then if she needs me to hear it, I can have a discussion with you.
We're all set with Mr. Rosier.
All right, thank you. State of Florida versus Daquan Smith. Mr. Smith, good afternoon.
Good afternoon, sir.
Mr. Smith, you are here based on an allegation of a new law offense. That law offense is in 2022 CF 11152. The allegation is possessing heroin with intent to sell or deliver, possession of ammunition by a convicted felon, possession of cocaine with intent to sell or deliver. In just a minute. Based on the affidavit, the court finds probable cause for those allegations. A bond in the new case be set in the amount, bond will be stayed in count one, $15,000. Bond in count two is going to be set in the amount of $5,000. Bond in count three is going to be set in the amount of $5,000. You're also out on probation. That case is case number 210623. That is a weapon-related offense, and you're on probation. In 2021-804, also a weapons-related offense. We're just going to find an on-view violation of probation on both of those cases. Bond will be set in the amount of none. I'll appoint the Office of the Public Defender on all three of your cases.
Your public defender, you can call him.
State of Florida versus Willie Flores.
Hi, good morning. Your Honor, Mr. Flores indicated he wishes to resolve his case today, just so the court's aware.
God bless you, Your Honor.
In just a minute. State, have you made an offer to resolve Mr. Flores' case?
Yes, sir.
Yes, Your Honor, sorry. Defense, was it a withhold?
I believe it was an adjudication.
Yes, an adjudication, credit time served, court costs, and I believe there's a no return associated. I can't.
Not sure I'm going to accept that on.
No, it's not no return. It's just the AG court cost, credit time served.
Okay. Mr. Flores has 7 felony convictions, 38 misdemeanor convictions. He was last with us on October 30th, 2022.
Thank you, Your Honor.
I'm not sure I'm going to accept this offer of resolution, Mr. Flores. You've been.
I won't do it again, Your Honor.
I'm having a tough time believing that, Mr. Flores.
Just don't say anything. Just wait.
What's Mr. Flores' credit for time, sir?
He was picked up on the 24th, so I think it would be 2
days?
days.
No, I'll tell him. And Your Honor, I would just make the argument as to the offer. Mr. Flores is homeless. This is a crime of homelessness, and that's why I believe it is a fair offer for Mr. Flores. I understand, notwithstanding his criminal history, this was.
I know things can't be easy for Mr. Flores, but wouldn't a resolution that encompasses some services be a more reasonable resolution? I don't know what's available to us under the city statute, but having him arrested and released and arrested and released over and over and over again doesn't seem to be a viable solution.
I'm looking for a job, Your Honor.
We're gonna come back to Mr. Flores' case.
I'm going to readdress you, okay? She's going to bring you
State
back.
of Florida versus Jakari Myers.
You're going to bring it back there real quick, and then you'll come back in. Wait, hold on. Wait for it. Go back in here.
Mr. Mayers, good afternoon.
Mr. Mayers also would like to resolve his case if possible, Your Honor. The agreed upon disposition is an adjudication court cost and credit for time served.
Mr. Mayers has no prior criminal history. Mr. Mayers, it's been represented that you wish to enter a plea to disorderly conduct. That will be a conviction on your record. You may qualify for some services or some programs through the state attorney's office. I won't talk you out of taking a plea. I'll accept the plea offer today, but that will go on a criminal history. I just want you to be aware of that and factoring that in.
Disorderly.
I'd also grant you a bond in the amount of $250.
Disorderly conduct.
I'm not showing any prior criminal history, so be unfortunate to put a blemish on your history. Says that you're attending UCF?
You have to catch.
I used to, yeah.
You used to?
I don't have to catch it out of Florida.
I'll resolve the case if that's your decision. I just don't want you to feel pressured or forced into it.
Resolve the case.
Your Honor, may I approach quickly?
Yeah, come on up. All right, Mr. Mayers, did you have a chance to go over the plea form?
Yes, we did.
You decided that's what you want to do?
Yes,
Okay.
and it's a withhold of adjudication, Your Honor.
Thanks. Mr. Mayers, I have a document here, looks like this. It's the plea form that I just watched you sign. Did you read this document? Did you have enough time to go over your decision with Ms. Lamphere? What your signature tells me is that you understand you have a right to have a jury trial. Even to this allegation, at the jury trial, the state of Florida would have to prove, or the city would have to prove to a jury beyond and to the exclusion of every reasonable doubt that you committed the elements of the offense that you're charged with. At that trial, you would have an attorney with you assigned to you. You would have had they would have been cross-examining witnesses, examining the evidence against you. You could have presented your own witnesses and evidence. You could have spoke at your trial or remained silent. You could have had the trial recorded and appealed any error that occurred in the process. Do you understand you are giving up all of your trial rights? Because if I accept your admission or your plea of no contest, I'm going to withhold adjudication, give you some court costs, and we're not going to be having a trial in this matter. Do you understand that? Is anyone forcing you or pressuring you into making this decision?
Sir.
Has anybody made you any promises other than what's written on your form?
Sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making? Do you understand if you're not a United States citizen, entry of this plea would subject you to deportation? And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. I'm not even sure if that applies to city ordinances, but that's the state of the law. Do you understand? Find that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss this decision with an attorney briefly. Are you satisfied with her help?
Sir.
You've indicated to me no one's forced you or pressured you into making this decision. You do so of your own free will. Court accepts your plea of no contest. I will withhold adjudication, which means you're not formally convicted of a crime, but it will appear on a criminal score sheet. I will sentence you to court costs. Those court costs?
No.
Nope, I don't, yeah. It's how much? You owe $223. How long do you need to pay that back?
I can pay it now.
Okay, I'm gonna give you a period of 12 months. So anytime in the 12 months, make the payments to the clerk of the court. Does he pay clerk of the court on a city ordinance?
Yeah.
Clerk of the court. Pay the clerk of the court, and you'll be square with them.
Sir.
We'll give you credit for the time that you've already served, which is 2 days. Be careful downtown. Those guys don't play down there, so. All right, good luck.
You're welcome. Your Honor, Mr. Springs also indicated he would like to resolve his case, and the offer we received was an adjudication, court costs, and credit for time served.
All right, did Mr. Pilgrim bond out? Thank you. Mr. Springs is in exactly the same position as Mr. Flores. Swear in, Mr. Springs, please.
Swear in.
Swear in, Mr. Springs.
Oh, I'm sorry. You swear affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
Springs, I'm going to be handed a document that indicates that you wish to enter a plea of no contest to City Ordinance 33.06, which is open container. Is that what you wish to do?
Yes.
I suspect you know that you're not supposed to do that, correct? The document indicates that you understand that you have a right to have a jury trial as to that allegation. At that trial, the city attorney would have to prove to a jury that you committed the offense that you were charged with. You could have contested the evidence and witnesses against you. You could have presented your own witnesses and evidence, had that recorded, and appealed any error that occurred in that process. Do you understand you are giving up all of your trial rights? Because if I accept this resolution, I'm going to go along with this recommended sentence, and we're not going to be having a trial in this matter. Do you understand that?
Yes.
Anyone forcing you or pressuring you into making this decision?
No, sir.
Anybody make any promises other than what's written on this document?
No, sir.
You under the influence of any alcohol, drugs, or mental issues at this time that cause you not to understand the decision that you're making?
No, sir.
You understand if you're not a United States citizen, entry this, well, never mind. Based on our discussions, Mr. Springs, the court's going to find that you appear to be alert, intelligent. You've had an opportunity to think about this decision, discuss things briefly with our attorney. You satisfied with her assistance?
Yes.
All right. I'm not going to appoint her because that will cost you some money. So she explained your rights as a friend of the court. The court's going to accept your plea of no contest to violating the city ordinance. And the court will adjudicate you guilty, sentence you to the time you've already served, which is 2 days, I think. Going to be some court costs that you will owe. Is it $223? You owe $223 or back to the state of Florida through the clerk of the court. How long do you think it will take you to gather that money up? Long time?
Yes.
How about 2 years?
Okay, thank
You have to pay those costs off within a period of 24 months to the Orange County Clerk of the Court. If you don't make your payments and they can't find you, they could request to suspend your driving privileges. Do you understand?
Mr. Springs,
All right, thank you.
please,
Hold on.
please do not drink on the sidewalk. I can't keep being nice. Gotta be careful.
Yeah.
I'm trying.
It's
But,
not,
I don't want to mess things up. Everybody was down there drinking. And I had 2 backpacks with me.
I know.
I'm down there drinking with 2 backpacks.
I got you.
Yeah.
Well, you know how it works out there, so,
I messed up having them backpacks.
I know, but your records you got so many offenses that it's becoming kind of discretionary as to whether we're just gonna keep cutting you loose, so be careful out there.
All right, thank you.
thank you.
Mr. Ware?
This is Mr. Ware. Could I just have 1 moment with him?
Sure. This is Flores, this is Ware. What are you missing?
PTR, will you run a number for me? It's, oh, sorry. Twenty-two, 022, 547. Is he a recent? Okay, thank you.
Mr. Ware, you are here with us based on allegations of disorderly conduct and the state misdemeanor of resisting an officer without violence.
And Your Honor, an offer has been made for an adjudication court cost and credit for time served, and Mr. Ware has indicated he would like to accept that plea.
State. Offer of resolutions, adjudication, time served.
Yes, Your Honor, upon reading the affidavit, I do see that there were fighting words based off the way it was charged. That was the offer I gave, since it was charged as disorderly conduct and state misdemeanors. The officer indicated that his resisting was tensing up during the arrest, and then he didn't charge it as resisting without violence, so I used my discretion on that.
Okay. Mr. Ware, in a moment, I'm going to be provided with a plea form.
Yes, you just need to sign it.
Thank you. Mr. Ware, what the, well, let's swear Mr. Ware, please.
Raise your right hand. You swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Mr. Ware, what this document tells me is that you wish to resolve your case. You have two allegations. One's a violation of City Ordinance 43.06, which is disorderly conduct, and one is a violation of City Ordinance 43.3, which is a violation of state misdemeanors. Document indicates that you wish to plead no contest to those counts. Is that correct?
No contest.
Yes, sir.
You understand you have a right to have a jury trial as to those allegations, and at the jury trial, the state of Florida would have to prove those allegations against you beyond and to the exclusion of every reasonable doubt through their city attorney. At that trial, you could have presented your own witnesses and evidence. Your attorney would be looking at the witnesses and evidence against you. You'd have a right to have that recorded and appeal any error that occurred in that process. You understand you've given up all your trial rights, because if I accept this resolution, I'm going to go along with this recommended sentence. We're not going to be having a trial as to this matter. Do you understand that?
Yes, sir.
Anyone forcing you or pressuring you into making this decision?
No, sir.
Anybody make any promises other than what's written on this piece of paper?
No, sir.
Are you under the influence of any alcohol, mental illness, or drugs that cause you not to understand the decision that you're making?
No, sir.
Under the influence of any alcohol or drugs that are causing you difficulty understanding?
No. Say it again. He just came.
Yeah, I understand. I understand. It's a lot going on at the same time.
Yeah.
Are you under the influence of any alcohol or drugs at this time that cause you not to understand what we're talking about?
No, sir.
And any mental issues, or are you on any medications that are affecting the way you think?
No, sir.
Court finds that based on our discussions, you appear to be alert and intelligent. You've had an opportunity to think about this decision and discuss it with an attorney as a friend of the court. Court's going to accept your plea of no contest to disorderly conduct, a city ordinance, and a violation of state misdemeanors, a violation of city ordinance. We'll adjudicate you guilty. You're going to be sentenced to the time that you've already served, which is 2 days. Court costs are going to be $223. How long is it going to take you to put $223 together?
I get paid every week, so I'll pay it in probably like a week.
About a year.
Okay, a year.
Fair? All right. Pay off your court costs within a period of a year to the clerk of the court. You won't have an issue with them. If you don't make your payments, they can't find you. They could suspend your driving privileges. You understand?
Sir.
30 days to appeal. If you wish to appeal, you must do it in writing. Can't afford an attorney, won't be appointed for you. Just so you know, I think you are now trespassed from that 7-Eleven.
Yeah, it was kind of weird. I went in there to buy something, and the police had already been there.
Yeah.
But when I came out, the store owner came out and was like talking trash to me, and then
Yeah, I think they'd seen you in there before, but you're trespassed from there. So I would have, if you go back to that 7-Eleven, I think they might charge you with a first-degree misdemeanor. So I'd avoid that one. All right.
Other 7-Elevens, just not that one, okay? You're all set. Take your paperwork and you're done.
Good luck, Mr. Ware.
No, you don't need it back.
Yes, sir. State of Florida versus Cornelius White. Mr. White, good afternoon. Mr. White, you were arrested based on an allegation of disorderly conduct, violation of City Ordinance 43.06.
Can I mask up?
Yes, sir.
Looks like a panhandling type offense. You don't have a bad prior criminal history. You're out on bond. I'll just alleviate your concerns. I'm going to take no action on the 2022 CF 9062. I do not find this to be a crime of violence or a crime that gives the court any concern about your continued release on bond on that case. You have a bond on this case. Your bond is set. I'm going to reduce your bond down to $250 and appoint the Office of the Public Defender.
You got a bond.
I said, got a question. How long am I here?
How long are you there?
How long I'm gonna be here for?
Till you post your bond. If you post your bond, you'll be released.
If I don't, you don't know.
If you don't, your attorney will probably get you in front of your trial judge, and I suspect they might consider a time served offer on the new case. I don't know what's going on the old case, so.
All right. Thank you.
Yes, sir. All right, that leaves Mr. Flores and Mr. Blackwood. Who'd you like to do first, Ms. Flores? Ms. Lamphere?
Either one, Your Honor.
Let's take Mr. Flores's case.
Let's come on up.
Thank you, Your Honor.
Mr. Flores, we're going to place you under oath.
Raise your right hand. You swear or affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
He said I do, sorry.
Thank you.
Yep.
Thank you, Your Honor.
Mr. Flores, you seem very nice. I know you're a little bit older than me. You getting tired of this yet?
Yes, sir, I am, sir.
Are there any resources out there that you can tap into?
I'm going to the labor pool, sir.
Labor pool?
Yes, sir.
How about housing?
Thing in the morning.
You going first thing in the morning?
Yes, sir.
Do you have housing? So when you're released, where are you going to go?
I don't know.
Back to the streets?
To the labor pool.
To labor pool? But they don't provide you a place to be, right?
Yes, sir.
And you've been to all the shelters? You've used up your time there? You're getting a record that's so bad that some judges, myself included, are going to be hesitant just to cut you right back loose out onto the street.
Yes, sir.
So keep that in mind when you come into contact. They're getting real serious on panhandling too and walking in amongst the cars in traffic and stuff. So you're going to have to figure out another way to make a living.
Thank you, sir.
I know you've said this before to other judges, so I'm having a little difficulty, but I'm pulling for you.
Yes, sir.
Flores, I've got a plea form. The document looks like this. Tells me that you wish to plead no contest as charged to disorderly conduct in violation of City Ordinance 43.06. Is that what you want to do?
Yes, sir.
You have a right to have a jury trial as to that allegation. At the jury trial, the state of Florida would have to prove to a jury through their city prosecutor that you committed the offense. You'd have an attorney with you. They'd be cross-examining the witnesses and examining the evidence against you. Could have presented your own witnesses and evidence. Could have had your trial recorded. You could have testified or remained silent and appealed any error that occurred in that trial process. You understand you've given up your trial process because if I accept this resolution, I'm going to sentence you to the time that you've already served, give you some court costs, and then cut you loose, and there will be no trial. You understand that?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Anybody make any promises other than what's written on your plea form? Are you under the influence of any alcohol or drugs at this time?
No, sir.
All right. Do you have any mental issues that are causing you difficulty understanding the decision that you're making?
No, sir.
Taking any meds?
No, sir.
Court finds that you appear to be alert and intelligent,
Sir.
polite. You've had an opportunity to think about this decision and discuss this with the court. The court's going to adjudicate you guilty of the city ordinance of disorderly conduct, violation of 43.06. You're going to be sentenced to the time that you've already served, which is 2 days, and you're going to owe $223 in court costs.
Yes, sir.
Imagine that's going to take you a while to get together, so I'm going to give you a period of 36 months, 3 whole years to make that payment to the clerk of the court. As long as you make a little payment whenever you can, you won't have an issue. You don't make your payments, and they can't find you, they could request to suspend your driving privileges.
Yes, sir.
You have 30 days from today's date to appeal this judgment and sentence. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. No more walking in amongst the cars, okay? All right, good luck.
I go home today?
Yep, you're going to be heading home today.
You're welcome.
Thank you, sir.
Yes, sir.
God bless you.
You too. Last but not least, we have Mr. Blackwood's case. Good afternoon, Mr. Blackwood. What's the anticipated, he's out on bond on a possession. This doesn't contemplate a resolution of that, does it?
No, Your Honor. I believe that's in pretrial diversion posture. It might already be closed. This would just be a withhold court costs and credit for time served.
Mr. Blackwood does not have a bad criminal history. It looks to me he was just trying to sleep somewhere. Mr. Blackwood, we're going to place you under oath.
Raise your right hand.
swear affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Mr. Blackwood, in just a minute, you're going to sign a document that's going to tell me that you want to resolve your case. I just watched you sign it. What that document says is that you've got a right to have a trial as to this allegation. This is an allegation of trespass on property after you've been warned not to go there. That is a violation of state statutes, a first-degree misdemeanor, a violation of 810.09 subsection 5. This document tells me that you want to plead no contest to that charge. Is that what you want to do? Do you understand that you have a right to have a jury trial, and at the jury trial, the state of Florida, through their prosecutor, would have to prove to a jury that you committed the offense of trespass after warning? At that trial, you'd have an attorney right there with you. They'd be cross-examining the witnesses and examining the evidence against you. You'd have a right to speak at that trial, present your own witnesses and evidence. You'd have a right to not speak if you chose to do that. You'd have a right to have your trial recorded and appeal any errors that occurred in that process. Do you understand you're giving up all of your trial rights because if I accept your plea of no contest today, I'm going to just sentence you to what the state's recommending, and we're not going to be having a trial. Do you understand all those things? Is anyone forcing you or pressuring you into making this decision? Anybody make any promises? Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making? You understand if you're not a United States citizen, entry this plea would subject you to deportation? Yeah? And if you ever before have been convicted, well, never mind. Court finds you appear to be alert, intelligent. You've had an opportunity to think about this decision. Actually, that's a misdemeanor, so that does apply. If you've ever been convicted of a sexually violent or sexually motivated offense, entry this plea could subject you to involuntary civil commitment. I don't know if that applies to you, but you understand that's the state of the law. Based on our discussions, I find that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss things with an attorney. Did I appoint the Office of the Public Defender on this one?
No, Your Honor.
You've had an opportunity to speak with an attorney as a friend of the court to advise you on your rights. Court's going to accept your plea of no contest to trespass after warning, withhold adjudication, and sentence you to court costs. You'll get credit for time that you've already served, which I think is 2 days. And the court costs on a misdemeanor are going to be $273. How long is it going to take you to gather that up? Sorry, don't know? I'll give you a period of 3 years to make those payments to the clerk of the court collection program. As long as you make a little payment every once in a while, you won't have an issue with them. If you don't make any payments and they can't find you, they could request to suspend your driving privileges. Do you understand that? All right, thanks. You staying in your car? You're not staying in your car? All right. So you got a place to be when you're released?
Mr. Blackwood, please, please, please do not go back to that Sam's Club.
Yeah, you can't go back. You can't go back to the Sam's. They're looking for you, and if you show up there again, they're going to arrest you, okay?
Me and you both will be in trouble.
All right, good luck.
Judge,
And court takes no action on the possession of cocaine case 2021 CF 903.
Thank you, Your Honor. I think that's everybody.
That was the last of the cases that I have. Anybody have any additional? Good morning, Mr. Alvarado.
Morning, Judge.
I'm well, thanks for asking. Mr. Alvarado, you are here with us based on an allegation of battery domestic violence related. Looks like you qualify for pretrial release with a bond. I do find probable cause for your arrest. I'm going to set bond the amount of, well, hold on just a sec. I couldn't see that we have a witness present. So before I get into the bond conditions. Good morning.
Good morning.
Would you tell me your name, please?
Sheree Fuentes.
Thank you, Ms. Quintez. We're going to place you under oath.
Okay.
Raise your right hand. You swear affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Fuentes, you are, let's see, listed as the alleged victim on the case. I have made a probable cause determination, but I would like to consider your input in making some decisions about the conditions of bond, whether you wish to have contact with Mr. Alvarado and whether you are in fear of Mr. Alvarado. You wish to give me some information?
I don't fear him. I'm not, I don't feel like my life's in jeopardy.
Can I ask if you guys live together?
Yes, but currently now I'm staying with my grandmother.
All right, thank you. You intend to stay at your grandma's or?
Yeah, for the time being, yes.
Okay. All right, do you wish to have contact with Mr. Alvarado?
Yeah.
Do you have any personal belongings still at the Oak Court address?
Yes.
Do you have a means of communication like a cell phone?
I'm sorry?
Do you have a cell phone?
Yes.
All right, if you were in fear of further acts or concerns of violence, would you be willing to call law enforcement?
Of course.
All right. Thank you. Do you wish for Mr. Alvarado to return back to the address?
To the apartment, yes.
The Oak Court address?
Yeah.
All right, thanks.
Okay.
Are you both on the lease?
Yes.
Ms. Tyner, any questions of the witness?
I think you covered it all. I do just have a couple of arguments once defense.
All right,
defense doesn't have
thanks.
questions.
Is Mrs. Skirdo?
Yes, Your Honor. No follow-up.
Thank you. Ms. Tyner, if you'll speak into the microphone so Ms. Skirdo can hear you.
Yes, Trustee Tyner for the state of Florida. The state does have concerns that there was a child present, and it appears the victim was holding the child while some of this incident occurred. We appreciate that the victim's asking for contact, but we would be asking for no hostile contact at least, and separate residences until this situation is handled. Like I said, I do have concerns that the child was in the arms of the victim while some of the violent acts occurred.
It wasn't me.
I understand,
Oh, okay.
but I have to go off what the affidavit
Okay, no, okay, that's fine.
And if you have any other concerns, you can speak with our office. We will be reaching out to you, but just for today's purposes, I do have concerns.
Ms. Fuentes, where's the child? Is it with you at Grandma's?
Yeah, my grandmother's.
All right, thanks. All right, the court has found probable cause. Based on the sworn testimony before the court, I am going to allow no hostile contact. Mr. Alvarado, that means exactly what it sounds like. Can't put your hands on Ms. Fuentes without her permission, no getting in each other's faces, no swearing, no threats or arguments through social media or online. Do you understand?
Judge, I understand.
Thank you. Court will allow you to return to the property at on the Oak Court address in St. Cloud. The court is going to order that you maintain separate residences while this case gets sorted out. I previously appointed the Office of the Public Defender.
I have a question.
Ma'am?
The Oak Court isn't our address. It's in Winter Haven. That's my aunt's house.
My apologies.
It's okay.
So this incident took place at your aunt's house?
It took place at his mother's house.
His mother's house.
I went to my aunt's house after the incident.
Okay. Did you guys previously live with his mother?
Before, yes.
Okay. All right. I'm just going to then delete the no return provision, but I will require that you maintain separate residences while this case is pending. All right. Thank you.
Your Honor, also, will there be a bond amount and PTR in this case?
Yeah, bond amounts $500 plus pretrial release conditions as previously announced.
Thank you. And the conditions are no hostile contact. Mr. Alvarado can return to the address, but they have to maintain separate residences, correct?
Right. Correct.
Your Honor, just before we move on, can we, Mr. Adams, Kenneth Adams, those bonds were stayed, correct? Sorry,
The bonds were stayed.
Yes, thank you. Be sure.
All right. Thank you. State of Florida versus Dana Andrews.
President approaching.
Thanks. Morning, Mr. Andrews.
Good morning. How you doing?
I'm well, thank you. Mr. Andrews, you were arrested based on an out-of-county warrant. That's out of Seminole County. I'll give you as much information as I have. It says that there was a failure to appear for veterans diversion hearing. Judge Woodard issued a warrant for your arrest based on that failure to appear. The bond is none at this point. We'll let Seminole County know that you're here with us and get you over there as soon as possible to address that situation.
What do they have the date of that that missed court appearance?
I'll
'Cause I
try
just was
and-
talking to my JV my veterans outreach officer on Friday. I was at the 2 East at Lake Nona. He never mentioned a warrant out or anything. And I'm supposed to go to Sunrise tomorrow to get treatment for Veterans Court tomorrow. The VA is paying for a 30 to 45 day program. I don't understand like what's going on. Like, is that going to affect my inpatient program? Because I never got mentioned a warrant. I'm like confused, and I never missed a court date. Like, I'm confused. Like, is this like I don't understand what's going on.
Yeah, I wish I could be more helpful for you. It's out of another county, so my information is limited. All I can tell is what's in the remarks section of the warrant. I can see that it was Judge Woodard. I can tell it was for a diversion hearing through Veterans Court. I don't see a date when it's alleged that you missed court. Only that.
Because from my knowledge, I got court on the 29th, which is Thursday, Veterans Court, and I didn't know I never missed a court hearing with Veterans Court.
Yeah, I've got no reason to disagree with you. I've got not enough information to answer your questions. I'm sorry, that's probably not a satisfactory answer, but I gave you all the information that I have. We'll let Seminole County know that you're here with us. Are you represented by the Public Defender's Office over there?
Yes, Public Defender's Office. Yes.
Okay. I don't know if the
Veterans Court though there. Like I haven't missed any of those court days. I'm like confused. Like how do I have a warrant if I never missed any court hearings? I don't know whether I'll speak with him on. I'll speak with my probation officer on Monday about it.
Yeah, I don't know whether the PD's office here would, as a courtesy, reach out to the vet court over there, but that's all the information I have for you. So
Okay.
sorry, can't be
Thank
more
you.
helpful. Yes, sir.
Your Honor, I'll make all my efforts to reach out to Seminole.
Thank you. That's kind of you. State of Florida versus Kimberly Caldwell.
She bonded.
Thank you. State of Florida versus Tiffany Cox.
President approaching.
Good morning, Your Honor.
Good morning, Ms. Cox. Ms. Cox, you are with us based on an allegation of a new law offense. That offense is operating a motor vehicle without a valid driver's license and leaving the scene of an accident with property damage. I took a look at the charging affidavit. I do find probable cause for your arrest. I'm going to set bond in both of those counts in the amount of $500 for a total bond amount of $1,000. That's the good news. The bad news is you're out on bond on another case, and that's 2022 CF 1623. That case is a felony allegation of possessing a controlled substance and possessing drug paraphernalia. I have probable cause to believe you committed a new law offense while you're out on bond on a felony. So I'm going to revoke that bond. You're going to have no bond for the time being until you can get in front of your trial judge and let them know what's going on. That may be me. I'm not sure. I will appoint the Office of the Public Defender on the new case as well as the old case if they weren't previously representing you. Thanks.
So, I'm trying to understand. So I'm not getting no bond to get out?
So you got a bond on the new case. You have no bond on the old case because I found that you committed a new law offense while you were out on bond. I'll allow you to petition your trial judge. That's either me, Judge Nix Walker, or Judge Young, and your attorney knows how to get you in front of them, and they can revisit this decision. But for the time being, you got no bond on the old case.
Okay, but I can still bond out with my new one.
Probably wouldn't be a good idea because then you won't get credit for time served. But you can run that question by your newly appointed attorney, and they'll talk strategy with you as far as the bond on the new case.
Okay.
Thanks. State of Florida versus Tiana Delgado Gambon.
President approaching, and Your Honor, I do have some information regarding the residence that Ms. Gunbone would like to ask the court.
Thank you. Good morning, Ms. Gabon. Ms. Gabon, you were arrested based on an allegation of battery domestic violence. Based on what's in the charging affidavit, I do find probable cause for your initial arrest. I am going to set bond plus pretrial release. I do believe that you qualify. Ms. Izquierdo, do you wish to be heard as to conditions of her release?
Yes, Your Honor. Ms. Gambon stated that currently, well, when this incident happened, it seems that the alleged victim and herself were living at her grandparents' house, and it appears that after this incident, he would not be living at her grandparents' house, so she's requesting to return to her grandparents' house and for them to maintain separate residences.
All right, I don't think I have a problem with that. State, do you have any additional information for me?
I do not have any additional information, but I don't object to that if it's the grandparents' house.
All right, thank you, Ms. Tyner. Ms. Gabon, the court is going to, as a condition of your pretrial release, impose no contact. That's going to be no contact between you and Alana Grace Villata?
No, Your Honor.
No, sorry, that's the daughter. Sorry about that.
Antonio Villata Marroquin, first page, second sentence.
All right, no contact with Antonio Villata Marroquin. And the court will order that you maintain separate residences. Pretrial release is going to verify that that gentleman is no longer at the property. If he's not, you're welcome to return. If he is there, you have a no contact order, so you won't be able to be there if he's there. Does all that make sense?
Yes, sir.
All right. No contact means exactly what it sounds like. No contact in person, through third parties, or electronically. Thank you.
And Your Honor, what is the bond amount?
500 plus pretrial release, and I'll appoint the Office of the Public Defender if I didn't previously announce that.
Thank you, Your Honor. And in the event, would she be allowed to return one time with law enforcement if the alleged victim is still residing at the address?
Of course. If that person is still there, won't leave, you can return one time with law enforcement and get some personal property while this case is pending.
You're welcome.
State of Florida versus Andrew Martinez.
He refused, Your Honor.
Okay, let's see.
Can we reset him one time till tomorrow?
Yep, we'll reset his case. Probably would have got some reasonably good news this morning, but we'll try again tomorrow. State of Florida versus Timothy Price.
President approaching. And Your Honor, Mr. Price wanted to inform the court that he has been found incompetent to proceed. I do not have that information in front of me. All I have is a police report, but he did advise he wanted the court to learn the information.
All right, thanks for that info, Mr. Price. Mr. Price, you are here with us based on an allegation of battery, domestic violence related. I guess that's an issue between that is alleged to have occurred between you and your brother. I read the charging affidavit. I do find probable cause for your initial arrest. Let me take a look, see if you qualify. You do. Court's going to impose a bond in the amount of $250 plus pretrial release conditions. Those release conditions are that you're to have no contact for the time being with your brother. You're not going to be allowed to return to the property where this is alleged to have occurred, which looks like the Huey Street address. And I will appoint the Office of the Public Defender to represent you. They'll look into the competency issues. Thank you. State of Florida versus Luis Rosario.
President approaching.
Good morning, Mr. Rosario.
Good morning, John.
Mr. Rosario, you are here with us based on an allegation of battery on a person 65 years of age or older. I took a look at the charging affidavit, and I do find probable cause for your initial arrest. The court is going to set a bond in your case, appoint the Office of the Public Defender to represent your interests. Your bond is going to be set in the amount of $1,000 plus pretrial release conditions. For the time being, you're not going to have contact with Carmen Pacheco, and you're not going to be able to go back to the Atlas Drive address. I will allow you to return one time with law enforcement, to get some personal property while this case gets sorted out. Thank you.
Your Honor,
Yep.
alcohol seems to be a contributing factor. We would be asking that he not consume any alcohol.
As a condition of pretrial release, Mr. Rosario, you're going to have to abstain from alcohol.
And Your Honor, prior to us concluding with his hearing, may I have a moment to confer with him? He would like to ask me something.
Of course.
1 second. Yeah. All right, let me ask. Your Honor, Mr. Rosario advised that the house is divided into 2 sections, and it appears that the garage was turned into a living residence for Mr. Rosario, so he's requesting if he could return and reside in the garage.
Yeah, that's under one roof, and I'm uncomfortable with that, absent a little bit more information. He can make that request in front of his trial judge in a motion for modification of bond. I will allow him to return that one time to get some stuff while this case is getting sorted out.
Thank you, Your Honor.
Thank you.
Have a seat, sir. Oh, thank you, sir.
State of Florida versus Mary Shepard.
President approaching, and Your Honor, I do have some information regarding Ms. Shepard.
Thank you.
Good morning, Judge.
Good morning, Ms. Shepard. State, I think there's a Scrivener's error in the charging affidavit indicated on 724. I think that's supposed to be a 9. Ms. Shepard, there's an allegation of battery domestic violence related for that unfortunate incident between you and your daughter. I have read the charging affidavit, assuming the issues in the charging affidavit are true and correct, which at this stage I must. I do find probable cause for your original arrest. I think the charging affidavit indicated that you are on holiday. Mrs. Skirdo, what additional information would you like me to consider?
Yes, Your Honor. Ms. Shepard advised, as the police report states, they were here on holiday from the UK, and her flight is scheduled to leave on Thursday. Ms. Shepard's concern is the no victim contact because her and the alleged victim were scheduled to leave on the same flight. It appears that Ms. Shepard also indicated she cares for the alleged victim's husband, who is terminally ill. Therefore, Ms. Shepard is requesting for no hostile contact instead of no victim contact so that she can return home in the flight.
Ms. Tyner, I know you're, Ms. Tyner, State, I know you're doing double duty here, but the request is
No hostile contact.
no hostile contact. Was there a face sheet done on this case? Officer Jenkins, do we see any prior criminal history?
Your Honor, we are unable to run it because she's from the UK, so we are
Right.
able to verify the history.
All right, based on the charging affidavit and the specific facts of this case, well, let me ask Officer Jenkins, was there any contact with the alleged victim in the case?
No, sir, because it was an international phone number.
All right, the court is going to order that Ms. Shepard have no hostile contact with her daughter. No hostile contact means exactly what it sounds like, Ms. Shepard. No loud verbal arguments, no putting your hands on your daughter without her permission, no threats or arguments through social media or electronically. Do you understand?
Yes, Judge.
All right, thank you.
The state would like to say, please stay in contact with Osceola County. I know you're going to be returning across the pond, so please make sure you keep up with this in case you ever want to come back.
Yep,
Yes,
thanks,
that's
Ms.
fine. Okay.
Ms. Shepard, I'm going to appoint the Office of the Public Defender to represent your interests. They're going to give you some contact information. You will need to return when and if the state makes a filing decision and brings formal charges against you. If you don't, the court's likely to issue a warrant, and that's going to be waiting for you anytime that you want to return. So it would be much easier and simpler, and there's probably some programs that are available to you if you stay in contact with your attorney and return as agreed.
And Your Honor, regarding release conditions, is the court imposing a bond?
Court's going to impose a bond of $250 plus pretrial release conditions.
Your Honor, I believe she does not qualify for BTR because she's international.
Court's going to set a bond in the amount of $250 with a. Court's going to set a $250 bond with conditions that she have no hostile contact with her daughter. Do they reside together in the UK?
No, sir, but my daughter she's recently married and she's married a chap that's terminally ill. So I have been going in every day to look after him as well.
All right.
It's
The court's
just a one-off incidents, unfortunately.
Yes, ma'am. The court's going to just make a condition of your bond that you maintain separate residences, that you not live under the same roof.
Oh, yes, that's fine, sir. Yeah.
All right. Okay, thank you.
Thank you.
Your Honor, ma'am, can she wait for me after so that I can give her information so we stay in contact? Okay, no problem. You're welcome.
State of Florida versus Donna Souza.
President approaching.
Yeah. AG court calls correct time served for the county ordinances. Sorry about that, Your Honor.
No problem. No, you're working and listening at the same time. Ms. Souza? There's a Sousa.
Yes, Judge.
How do I pronounce your last name?
Souza.
Ms. Souza, you are with us based on an allegation of sale or delivery of amphetamines. I believe that this was pursuant to an active warrant. I do not have a copy of the warrant, but it reflects that a judge has found probable cause for that allegation and set bond in the amount of $2,500. That apparently was Judge Arendis. Does Ms. Souza qualify for direct pretrial release?
Yes, sir.
Court is going to order that Ms. Souza be released on pretrial release, straight pretrial release, as she does qualify.
Okay, thank you, Judge, because this happened.
Ma'am, I would not talk about the facts of the case. Everything is being recorded and can be used against you.
Yeah, you're gonna make your attorney really nervous if you start talking to me about the facts of the case. So you'll be able to run any disagreements or potential defenses through your attorney. Just stay in contact with them.
Your Honor, can we add a no possess or consume no drugs?
Ms. Souza, as a condition of your pretrial release, you are to possess nor consume any illegal substances.
Okay, that's fine, Judge. Thank you.
Thank you.
Thank you. Have a seat, ma'am.
State of Florida versus Chad Sullivan.
Bonded, Your Honor.
Thank you. State of Florida versus Lorenzo Washington.
President approaching.
Morning, Judge.
Morning, Mr. Washington. Mr. Washington, you got a couple issues with us. The first is an allegation of fleeing or attempting to elude a law enforcement officer with lights and sirens activated. Took a look at that charging document, and I do find probable cause for your initial arrest. I am going to appoint the Office of the Public Defender on that case, and you set a monetary bond in the amount of $3,500. You also have the issues of what they found in the car, and that is allegations of possession of cocaine with intent to sell or deliver, and marijuana possession with intent to sell or deliver. I find probable cause for both of those offenses. Bond in count one is going to be set in the amount of $7,500, and count two in the amount of $2,500. As to count three, the court's going to find that that count is entirely subsumed by the count in count one and RORU on count three. As to count four, the court finds probable cause, but finds that that count is entirely subsumed by count two and RORU on that case. And on count five, the court finds probable cause and sets a bond in the amount of $500. So total bond amount will be $10,500. I will appoint the Office of the Public Defender on all those counts. Thanks.
Thank you, Honor.
And one question, sir, regarding the fleeing or eluding, that bond amount was $3,500?
Right.
Thank you. Okay, thank you, Your Honor. Have a seat, sir. You're welcome.
State of Florida versus Christian Rosa.
President approaching, Your Honor. He was reset from yesterday. I believe it was to address a bond amount. I'm not entirely sure.
I got a note on the docket saying I'm not sure why this was recalled either.
I think it was a recall. call, to do with case 22 CF 2693. And
All right,
I
I
think it was said that he was out, he had a failure to appear already in the computer.
Okay. I do see he's got a current no bond in 2022 CF 2693. Apparently that's for failing to appear. The court set bond on the new law offense, which was a possession of drug paraphernalia, in the amount of $250. That's all the information that I have, so I guess if he bonds out in Osceola, he needs to be transported over to Orange so he can take care of his FTA.
And Your Honor, the FTA case is 22 CF 2693.
Correct.
Thank you. Sir, did you hear that? Okay.
So, Mr. Rosa, I don't know what's going on in the other case, but Mrs. Scardo, can you ask whether he's represented by the Office of the Public Defender on that case over here?
Mr. Rosa, are you represented by the PD's office in Orange? Yeah. He says he is, Your Honor.
Ms. Lamphere, do you have your computer up and running? Can you look up case number 2022 CF 2693 and see if Mr. Rosa is represented by your office?
Yes, Judge, he is.
Okay. Can you tell me the status of that case? Is that currently a no bond for failure to appear?
It is in capious status, Your Honor. There is a bond discharge on September 12th. I'm just taking a look at the capious itself.
All right, Mrs. Scardo, your colleague over here, Ms. Lamphere, is indicating that it looks like the bond was discharged on September 12th for a failure to appear and is currently in capious status.
Yeah, and there's no bond. No bond on the capious.
Yeah, sounds like a no bond. So, okay, I think we've accomplished what we brought Mr. Rosa back for. Thank you. All right, that was the last of the folks other than our interpreter cases. I'm going to get the interpreter on board.
Did the court ever determine who John Doe was?
We did.
Okay.
Thought. Nope. Well, he says he's one of the Spanish speaking.
Okay.
We haven't
I
got
just wanted to make sure I didn't have a name.
haven't got to him yet.
Your Honor, I wrote it on top of the initial appearance information sheet, on top of his name of John Doe.
I've got it. Thank you, Officer Jenkins.
Thank you.
Good morning, Your Honor. This is Laura Bretaña, certified Spanish interpreter. The interpreter has not been sworn.
All right, Madam Interpreter, if you'll please listen to the clerk's instructions.
Raise your right hand. Do you swear or affirm that you will interpret from Spanish to English and English to Spanish the testimony you're about to hear today to the best of your ability?
Yes, I do. Laura Bretaña, certified Spanish interpreter.
Madam Interpreter, the first case that we have is Christian Arroyo Rivera. The case number is going to be a... Good morning, sir. Do you need the assistance of an interpreter, sir?
¿Usted necesita traductor o no? Sí, pero si le hablas en inglés, piensa que no te hace falta. So,
Sí, pero no
okay, so
entiendo
explica.
mucho.
Your
Ya.
Honor, he speaks English, but he doesn't thoroughly understand it. Therefore, he needs the interpreter to thoroughly understand what is occurring.
Of course. I'm happy to provide that for him.
Thank you.
Madam Interpreter, we have two cases, but they're investigative case numbers. First is 2022 I-102643. Looks like.
Okay.
And that's the only case number I have with a number of counts. Mr. Arroyo Rivera, good morning. You are here on 4 allegations.
Señora Arroyo Rivera, muy buenos días. Usted se encuentra aquí, tiene 4 cargos.
There is also an allegation that you have violated your probation.
Y también se le ha acusado de haber incumplido con el régimen de libertad vigilada.
That probation is out of Polk County.
Ese régimen proviene del condado de Polk.
The new law offenses allege driving while license suspended,
El nuevo incumplimiento de ley del cual se le acusa es de conducir con la licencia suspendida,
possession of a controlled substance,
tenencia de una sustancia regulada,
Possession of marijuana under 20 grams.
tenencia de marihuana menos de 20 gramos
And possession of drug paraphernalia.
y tenencia de instrumentos para el uso de drogas.
A review of your charging affidavit indicates that probable cause exists for your arrest.
Habiendo repasado el documento acusatorio, determinó que existen indicios de criminalidad para su arresto.
I will appoint the Office of the Public Defender to represent you on these two cases.
Se designa a la oficina del abogado de oficio para que les represente en ambas causas.
As to the driving while license suspended, your bond is set in the amount of $500.
En cuanto a la acusación de conducir con la licencia suspendida, la fianza es de $500.
As to the possession of a controlled substance, your bond is set in the amount of $1,000.
En cuanto a la acusación de tenencia de una sustancia regulada, la fianza es de $1,000.
As to the possession of marijuana under 20 grams, your bond is set in the amount of $500.
En cuanto a la acusación de tenencia de marihuana menos de 20 gramos, la fianza es de $500.
And as to the possession of drug paraphernalia, your bond is set in the amount of $500.
Y en cuanto a tenencia de instrumentos para el uso de drogas, la fianza es de $500.
Court also has probable cause to believe you have committed a new felony offense while you were on probation.
También este juzgado tiene indicios de criminalidad de que usted ha cometido un nuevo ilícito mientras se encontraba cumpliendo con régimen de libertad vigilada.
Court will find an on-view violation of probation.
Así que se determina que ha incumplido con tal régimen.
That is case number 21-2866 out of Polk County.
Ese es el caso 21-2866 del condado de Polk.
The bond on the VOP will be set at none at this time.
En este momento se impone prisión preventiva en cuanto al caso de incumplimiento con el régimen de libertad vigilada.
We will let Polk County know that you are here with us.
Y le informaremos al condado de Polk que usted se encuentra aquí con nosotros.
Thank you, sir.
Gracias, señor.
Madam Interpreter, the next case that we have is on our docket as John Doe 3220, but the identification is Hildian Fed Joe Bilvares Ortiz.
President approaching, Your Honor.
Thank you. The case number.
Habla en español.
The case number is 22I-102921 and 22I-102953. Good morning, sir. Please tell me your name.
Buenos días, señor. Por favor, dígame su nombre completo.
Olivares.
Repítalo, por favor, más lento, que no lo escuché.
Yul Olivares Ortiz.
Ilian Fed Jul Olivares Ortiz.
Yes.
All right, thank you, sir. You have been arrested for 3 allegations.
Muy bien, muchas gracias, señor. Usted ha sido puesto bajo arresto ante 3 acusaciones.
I have read the charging affidavits and find probable cause for the following counts.
Habiendo repasado el documento acusatorio, determinó que existen indicios de criminalidad para los siguientes cargos.
Violation of non-resident exemption of a driver's license.
Incumplimiento con los requisitos de la licencia de conducir para las personas no residentes.
Operating a motor vehicle without registration.
Conducir un vehículo de motor sin la debida matriculación.
And possession of a forged or stolen driver's license.
Y tenencia de una licencia de conducir hurtada o falsificada.
As to the violation of non-resident driver's license, your bond is set in the amount of $250.
En cuanto a la acusación de incumplir con los requisitos de licencia de conducir de los no residentes, la fianza es de $250.
As to driving without a motor vehicle registration, your bond is set in the amount of $250.
En cuanto a la acusación de conducir sin la matriculación del vehículo, la fianza es de $250.
As to possession of a forged or stolen driver's license, your bond is set in the amount of $1,000.
En cuanto a la acusación de tenencia de una licencia de conducir falsificada o hurtada, la fianza es de $1,000.
I will assign the Office of the Public Defender to represent you on all three of these charges.
Se designa a la oficina del abogado de oficio para que les represente en ambas causas.
Thank you, sir.
Gracias, señor.
Your Honor, are we going to accept the name that we have for him?
Su señoría, ¿vamos a aceptar el nombre que tenemos para él?
How was that identification made, Officer Jenkins?
Agente Jenkins, ¿cómo se hizo esa identificación?
I'm looking now. I think it's from FBI.
Your Honor, it appears that both BTR and defense received a.
Hold on, Mr. Skirdo. Let's let the interpreter do her work.
Creo que eso fue a través del FBI.
Mrs. Skirdo, anything else from defense?
It appears that the document that both PTR and defense received is from the FBI CJIS Division, Special Processing Center. Does the court have that document?
Su señoría, parece ser que el documento que recibió tanto la defensa como el programa de libertad provisional provino de la oficina CGIS del FBI. Es el área de procesamiento especial. ¿Este juzgado recibió una copia también?
Court will accept the FBI identification of the defendant, and the clerk's office will reflect that as the name on the case moving forward.
Vamos a aceptar la identificación del acusado por parte del FBI y de ahora en adelante, Secretaría utilizará esta identificación como la de este acusado.
Your Honor, defense also showed Mr. Ortiz the document and confirmed that the spelling and the date of birth is correct, according to Mr. Ortiz.
Su señoría, quisiera dejarle saber que la defensa le mostró el documento al señor Ortiz y él confirmó que tanto su nombre como la fecha de nacimiento estaban correctos y bien escritos.
Thank you, Mrs. Skirdo.
Gracias, licenciada.
I will conclude our hearing.
Esto pone fin a esta audiencia.
Any additional clients, Mrs. Skirdo?
No, Your Honor. At what time would the court like to begin tomorrow?
No escuché.
Toma asiento. At what time would the court like to begin tomorrow?
Same time.
Okay, thank you, Your Honor.
Thank you.
Have a great day. Bye-bye.
You as well.
Before we start the Spanish interpreters, could the clerk please write down the spelling of that name for the state?